Welcome on this day, 30 March 2023, day 5 of the testimony of Advocate Mkhwebane. I want to welcome all members present here today, mostly of them in the virtual platform, to welcome the public protector and her legal team, led by Advocate Mbofu. Welcome evidence leaders, Advocates Bauer and Mayosi, members of the media, our entire support staff, and the members of the public present with us in their various platforms. Again, we resume today, colleagues, to continue listening to the address of the public protector to this committee on the issues that are in our statement. We concluded yesterday, whilst we were on the unit matters, Advocate Mbofu had listed 6 areas of focus or pillars. We dealt with the EMEA as well as the establishment issues. I don't know what his order for the remaining 4, which includes operations, qualifications, recruitment, procurement or equipment, depending on how he, I think our attention is going to be on those immediately as I hand over to Advocate Mbofu, who will indicate which of those he's starting with. So thank you very much. Over to you, Advocate Mbofu.
Thank you, Chairperson. Chair, unless I indicate otherwise, we will follow the sequence of those issues that you have correctly enumerated in the sequence that they appear in the report. Thanks. But Chair, there's a kind of new section which is like a general section that is also contained in the report, and I'm not sure at this stage whether I'm going to do it at the end of the 6th or somewhere in between, but I'll do it as a standalone. I won't mix it up. Yeah. And you'll see, Chair, when we get there, there's an area of the report which deals with you remember the public protector expressed how aggrieved she was with some of the unfair criticism, at least in her estimation, coming from Mr. Pillay, Mr. Godan, and at some stages, I think even their attorneys, where she feels that it went beyond, legitimate criticism. You'll also remember, Chair, that I can't remember which witness I was dealing with, but we demonstrated that those criticisms about the public protector being part of state capture and what have you, also featured in the judgment, in the so-called rogue unit judgment. And the judge is actually in the so-called rogue unit case found that those remarks by Mr. Kotan went overboard. And in the Pillay case, the judges went as far as to impose a punitive cost order against Mr. Kotan for making such remarks. So that whole section, that's the one I'm calling the general section, is fortunately actually contained in the report. So there's a whole heading where the public protector talks about remarks made against her. So we will fit it there, probably at the end after the 6 issues. But Chair, what I thought I should do, again in the spirit of killing many birds with one stone, and because we have already dealt with the so-called rogue unit judgment in parts, you'll remember that whole thing about the IGI, did she see or did she not see the IGI report? So I don't want to, the kind of approach I'm taking with the report of blow by blow, I'm not going to do the same with the judgment. So the judgment, I'm just going to pick up relevant parts here, because otherwise it will just take too long. But having said that, Chair, I'm building up to this. At the same time, I want you and the members effectively to know where we're going with all these 6 areas and what have you. What is the actual goal? And for that, Chair, if you allow me, we'll go to the judgment at paragraph 290, Tsepo. The so-called rogue unit judgment, that's case 36099. Okay, while she's looking for it, good morning, Public Protector.
Good morning, SA. Good morning, Chairperson, members of the committee, evidence leaders, and everyone, members of the public.
Right. You've heard that short address when I was engaging with the chair, just to confirm that you are obviously familiar with the judgment of, shall we call it, the backup bench. It was a full court in the North Gauteng division. The judges were Selby Bakwa, L. Windel, and AC Basson, with Bakwa J presiding.
Correct.
Yes. And we have dealt with this judgment in various guises, and we will, after we've dealt with the report, come back to it, subject to what I've said to the chairperson, that we won't read it paragraph by paragraph. We will cherry pick certain areas which talk to the 6 issues. But I thought, in fairness to the members and anyone else who's following this, because this is quite a long and complicated saga, even after you split it into 2. It would be fair to indicate what are the issues that we want to counter, really. Insofar as we know, most of these charges rely on judgments. So ultimately, that's where we should reference. So, Chair, if you allow me, I'll just read paragraph 290 of the judgment. It's got the 9 criticisms. Is it up yet? Oh. My file is broken. Yes, thanks. It's up, Chair. Right. So after, as you can see, it's paragraph 290. So obviously there's a lot that comes before it. But this is where the judges, Chairperson, kind of summarize the gist of their findings. And they say, and I quote at paragraph 290, we have already alluded throughout the judgment why we say that the public protector has not only failed in the exercise of her duties, but displayed bias towards Minister Kodan and Mr. Pillay. We conclude that taking into account the following, a conclusion of bias is warranted. Then they list the following 9 points. One, the investigation and the report fell outside the jurisdiction of the public protector as it related to events dating back to 2009-2010. No exceptional circumstances have been presented by the public protector justifying the investigation after an extraordinary lapse of time. Also, despite the fact that the previous incumbent had already in 2014 received a complaint about the alleged unlawful establishment of the unit, but elected not to investigate the complaint, the public protector nonetheless proceeded with the investigation. So there, Chair, if I may just comment briefly, we will demonstrate that there's no basis for that finding. Because according to the public protector, the rogue unit was still operational, actually. It was not dating back to 2010. It was operational even at the time of the report. Number one. Number two, that it's not true that the 2014 complaint was about the establishment of the unit. It was more about the HR issues. I think Ms. Mkhwebane said that. Then the second one, Chair, says the manner in which the public protector interacted with Minister Kodan during the investigation and releasing the report. Not only did the public protector elect not to engage with Minister Kodan's attorneys on record, the Section 79 notice was publicly posted on YouTube before giving any notice to him and his attorneys. Similarly, the report was presented to the media without any prior notice to Minister Kodan nor his legal representatives. Again, we'll demonstrate that this is just not true. There's no 79 notice which was publicly posted on YouTube. It just did not happen. So we don't know where the judges got that. And then says the reliance on the discredited KPMG report, despite it having been disavowed, and the Sikakane report, despite having it been widely discredited. She also failed to engage with the findings made in the Nugent report. We showed already yesterday that that's not true. She not only engaged with the findings made in Nugent report, she actually quoted them more than once in her report. And the KPMG report was not disavowed in total. The Sikakane report was not widely discredited by anyone. It's also just did not happen. Yeah. Then number 4, it says the blatant dishonesty of the public protector with regard to the OIGI report and her insistence on ordering a Minister of State Security to implement it in totality, a report that she has, according to the report, never seen. That by now everyone knows that that's just non-existent, factually incorrect, and we don't know where it comes from. And then 5, the public protector's pandering of the rogue unit narrative and their public reference to the unit as the rogue unit and as a monster, and her stated desire to defeat the monster displays a profound bias towards Minister Kodan and Minister Pillay. Well, that one doesn't even make sense. Firstly, it's what Chief Justice calls magnification. Some passing comment made in a meeting with IGI And then everyone calls the rogue unit or the so-called rogue unit. And we'll demonstrate that that's exactly what the public protector did. And I don't know how defeating a monster, if it's a monster, the unit means it's bias against Minister Mkhwebane and Minister Pillay, because their version is that they were not part of any rogue unit. Anyway, then number 6 is the public protector's complete disregard of the Sunday Times apology and the Kroon apology. Kroon apology, we've shown that it was an individual. The reliance of churches on Sunday Times, I don't think that warrants any comment. And then 7, public protectors' scurrilous allegations that Minister Mkhwebane deliberately misled Parliament, which I think they wanted to say misled. But yeah, apart from that grammatical error, the issue of the Gupta brothers and so on we dealt with yesterday. And then 8, the public protector's unwarranted and slanderous attack on Portal J. We'll deal with that. We'll come to it now. And the public protector's relentless pandering of the untruths of Mr. Pillay's qualification. That one we think is just a misunderstanding of what was being, whether the issue that was being investigated was a metric or a qualification. So, Chair, what I'm saying is that those are the 9 findings which probably got us here, or which were being relied on by the complainant in using this judgment as part of the material for this committee's proceedings. And it's so that's effectively what this evidence is going to be directed towards. So let's keep those at the back of our minds. And I think about 3 of them have already been dealt with. So as we go along, we'll cross-refer back to this. Thank you, Chairperson. Public Protector, I just want you know about that part of the judgment. And I think at various points of your evidence, we will then cross-refer to those to show you that this judgment is really not to be at a factual level. It cannot be relied on by this committee, or rather the factual conclusions thereof. Can you confirm that?
Yes, I can confirm that, and we will deal with it, referring to what transpired during the investigation.
Right. All right. And then I've already indicated at the end, we will then deal with the section that deals with 181.3, 165.4, the so-called YouTube section 7.9 release, and section 9 of the Public Protector Act. Yes. That's the section I touched on yesterday before, where I said the homework, where we spoke about the provisions of section 181.1 and 181.3. So can we also pack that section for after the 6 issues?
Okay, I'll deal with it.
Good. Then we go back then, Chairperson, to the next of the 3 issues, which is, as the Chairperson indicated, the equipment issue. Now, you will agree, Public Protector, that this, of all these issues that we deal with here, this should be the quickest, and we should not spend a lot of time on it for various reasons, because as I said yesterday, it's a straightforward application of the PFMA, whether something is procured properly or not procured properly. Number one. Number two, we're dealing with members of parliament here. They may not be lawyers, but one thing they know for sure is holding people accountable against the PFMA. That's what they do routinely for different institutions. You accept that?
That's correct, as much as they would also hold the public protector, who's also accountable to Parliament on how you utilize the budget or the resources allocated to us.
Yes.
And they rely on the Auditor General, which is also a Chapter 9 institution, on such issues.
Yes. Correct. And in fact, even the very same public protector, among other things, is held to account against the PFMA, correct?
That is correct, especially how we use our resources, the accounting officer, and then the public protector as an oversight authority.
Okay. All right. So then let's go and try and do it as quickly as possible. In fact, maybe I'll convert the logic. And in this one, Chair, I'll start with the conclusion, just so that, again, we know where we're going. Yeah. Can we go to page 70 of the report? That would be paragraph 5.3.31 onwards.
Come again? Paragraph?
5.3.31 on page 70, typed page 70.
Okay.
Right. It says the SARS, the first conclusion, PP. Maybe, yeah, I think read it out and then you can comment.
The first conclusion which was reached, remember, Chairperson, we said to remind you and the members of the committee, when we check the common cause issues, the issues in dispute, the evidence we have before us, what the law is saying about that issue. And then when we apply the law to the facts, then we come to the conclusion. The first conclusion was that SARS failed to provide me with documents relating to the procurement of equipment for the CBCU, NRG, and subsequently the SPU. Such conduct is in violation of section 181(4) of the Constitution.
Okay.
So in this instance, Chairperson, to take members of the committee to, yesterday we spoke about section 181 of the Constitution, dealing with all the Chapter 9 institutions. And how do we support constitutional democracy? Supporting constitutional democracy, meaning how state institutions should assist the public protector in the investigation, the human rights and all others in their investigation. So failing to provide the documentation by SARS led to the violation of this particular section. And in a proper way, that also leads to the contempt of the public protector, because when you go to section 9 of the Public Protector Act, which we will still go through, which is applicable to all those who are refusing to cooperate with the Public Protector. It's when the failure to cooperate to provide information, and also it's criminalized in terms of Section 11 of the Public Protector Act. So that's what they did. And I mean, if it was the Auditor General saying, can I get the documents of why you have the following equipment, I wonder whether they would have behaved the same.
Right.
Then the second one, it is extremely unlikely that a unit carrying out investigations on behalf of SARS would not procure equipment necessary for the fulfillment of its duties and functions. Because we've seen from the memorandum which was written by the minister through Mr. Pillay, through Mr. Kodanes, the accounting officer, to the minister, that there is a unit we want to supplement. We also then want to you to avail the resources so that whatever we would want to do can be done by NIA or State Security now, because it falls within their mandate. So 3, it is unclear why SARS and or the former employees would keep the procurement of equipment such a guarded secret. Without proper explanation, I can only infer that the procurement processes were not adhered to.
Yes, maybe let's just pause on that one, because again, you know, for lawyers, we might be familiar with what we call inferential reasoning, but actually it's logic which everybody applies on a daily basis.
Yes.
And so the idea, I think the example you've made of the Auditor General is also fitting here. In other words, there are certain circumstances just in normal life where if you require a certain answer about something and that answer is not given, you can infer that it means, and the usual example is the so-called smoking gun example. If there's a dead body and you are standing there with a gun and someone says, well, what happened? And you say nothing. And you don't say, no, I don't know, I wasn't here or whatever. Then we can infer that you are the person who shot the person dead. Just to make it.
It's just a pause for Advocate Bauer.
I'm just checking if Advocate Mpofu is giving evidence.
No, yeah, if you're checking, the answer is no. The question then is from what did you or why did you infer from their refusal, or rather, yes, from their refusal to account for any equipment that the inference is therefore that they did not adhere to procurement processes.
The inference was based on the fact that the allegation is saying the complaint and the allegation and the evidence independently acquired by the Public Protector was revealing that there is equipment which was procured, which is being utilized. Then from SARS and the implicated parties, we don't get that information in the commitment. You know, because our investigations are like that. We will have information when we conduct this. We ask you, assist us. But then sometimes whilst assisting us, we do other means of investigations, and we had the information that they have the equipment kept at the SARS building somewhere, and that information is that equipment is being utilized. And we had some members who were part of that operation who have utilized this. So hence the issue of why keep such information and not want to share the documents. You have the equipments, you are using the equipments. How did you procure the equipments? Because surely a state institution which is having assets, I mean, when they are going to be audited, surely they need to account for that. Where did you, if it's a donation, there is a process as well, which you need to follow. So it was purely based on that, hence my inference that this is like a guarded secret. And there was no proper explanation why this is being hidden so much.
Thanks, John. Then the next one, I think, is in the same mode. That's 5.3.34.
Yes, the existence of the unit is a non-disputable fact, and therefore the buying of the equipment is an obvious consequence of that, because anyway, we had the evidence that the equipments are there, and we are of the view that the failure and blatant refusal of SARS and its former employees to provide me with the records of the procurement and whereabouts of the said equipment is unwarranted and undermines my ability to perform my constitutional functions, again violating the constitution, because section 181 is very clear that state organs must assist such institutions so that we can perform our responsibilities as the public protector.
Yes. And okay, good. And that would go to section 181.3, the one about assisting you, and 181.4, which it says that state organs must not interfere with your functioning.
Yes, correct. Because, you know, if you refuse to cooperate, if you refuse to provide information and evidence, it's like then interfering with our operations. And why are you hiding the information so that we can also exonerate you as an implicated party? Because when we conduct an investigation, we are not conducting an investigation to find anything which is wrong against you, but we conduct investigation so that we can also exonerate you, because you need to assist us to assist you, basically.
All right. And just as an aside, Chair, we'll deal with it under the so-called general section that I defined. But one can flag that a breach of section 181.3 is actually a criminal offense in terms of the Public Protector Act.
Yes.
Okay, the next one.
The failure by SARS and denial by the former officials of the existence and purchasing of the equipment by SARS is a clear indication that such equipment was utilized for activities falling outside the SARS investigative mandate. So it goes back to that memorandum which was written by the then Commissioner Kodan to the Minister Manuel, where he was saying, this unit, we want to beef it up with the procurement or the funding of NIA by then, state security, so that we can conduct other activities. And at the end of the day, I also confirmed yesterday that, well, I'll still go back to the observations that it was very clear that I informed them, I'm not interfering with your mandate, continue to do investigations. Definitely we need to deal with crime. We need to deal with those who are in conducting illicit trading or, you know, impacting on our economy and all those. But at the end of the day, do it within your mandate. And I think that's what even the Commissioner Nugent, when he was dealing with the matter, we read the paragraph yesterday. And he was also saying they must do it within limits. So doing something within limits it means that do it within your mandate. So I think, Chairperson, when we go back, because we started at the end, you will see our ways of investigation, how we tried several times to get the information and the evidence from them specifically to indicate, provide with evidence. How did you procure this? Here's evidence. Here's the equipment. Whatever you're saying, you are spending, but we will see. We will show you where the responses was, no, we only spent 1 million on this and that. But then we have evidence which was independently acquired, which shows that around 40 million was spent, and evidence that there is this equipment which is lying there, equipment which is so sophisticated compared to what they are saying they've used to procure the equipment.
Thank you. All right. Now we'll go to the build up to that, but just for the sake of completion, in response to your, or rather in amplification of your point that the equipment was there. That was not disputable, but the issue, at least in this context, was how it had been procured. I'd like you to comment if you can take us to bundle H, item 1, Tsepo. It's a letter, I don't know what page, but it's a letter from SARS. Just check. Yeah. You remember this letter? This letter, I think we presented it to Mr. van Lochenberg in a different context, but I just want to deal with it now in relation to the topic that we're dealing with. It's addressed to you from the current SARS Commissioner, Mr. Kisweta.
Correct.
Yeah, and maybe you can read it, it's not long.
Yes, this was sent to me by the current commissioner, and the heading was report the investigation into allegations of the violation of the Executive Ethics Code by Mr. Godan. So it relates to this report we are doing. And I trust you are well and that you have started 2021 on a positive and constructive note. I wish to inform you that SARS will be vacating its premises at Riverwalk Office Park on the 31st May 2021. You may recall that the equipment that formed part of the Public Protector's investigation into the alleged so-called rogue unit was securely stored in the basement of the said premises under supervision of the DPCI and SSA. SARS will be relocating the equipment to a new secure location under supervision of the SAPS and the SSA at a date to be determined. You are most welcome to send representatives to oversee the relocation. Should you decide to do so, it will be appreciated if my office would be alerted to make the necessary arrangements. If we don't hear anything to the contrary from your office prior to 15 May in this regard, SARS will proceed with the relocation. So this was presented to this committee, and all of a sudden there was a letter which was written to the chairperson from the acting PP, which we will have to discuss and possibly go through it. But the main thing is that when we deal with the remedial action, because the remedial action, one of the remedial action was that the equipment and everything relating to the mandate of SSA should be taken over by SSA. So you can see here that now they are acknowledging it was overseen by DPCI and SSA, and then it should be under the responsibility of that. So I took it's the implementation of the remedial action.
Right.
And it relates to the very same issue of the equipment. Because the main thing is, again, going back to the investigation, you will see that it was such a very guarded or very, it was so secretive, not acknowledging from SARS that yes, there is this equipment. Yes, the equipment was procured. And we independently uncovered that there is this equipment. And that was also forming part of the charges against Pillay, Van Locherenbeck and Rich, is it Rich?
Okay. Thank you, PP. Advocate Impof.
Yes. Now, I wanted to say, Chair, that
We're trying to get the letter from the acting PO to from the DPP.
yes, panel
Yeah,
L,
which I didn't
no, it's
understand
actually-
why.
it's a letter from Mr. Kiswetter,
Mm,
which was written to the chairperson here.
okay. And copied the DPP.
Yes, actually it was written to her.
Mm.
Oh, sorry, it was not written to
Okay.
the chairperson was, this chairperson was,
Yeah, maybe you can talk to us and explain as to you're looking for that in aid of what point you want to put across
no, okay, Chair, okay, thanks.
whilst you're looking for the letter.
No, I've got it.
Okay.
What I was just saying that, well, firstly, let me just respond to the PP that the letter was sent to Advocate Galeka and that it was sent to the chair and the evidence leaders and copied to you and to me. Yeah. Oh. All right. So
Okay.
yes. Now, Chair, now I'm answering the chair. Chair, the point I wanted to make is really the same point I wanted to make when I presented this letter to Mr. Van Lochenberg, namely that whatever the controversies about the lawfulness or unlawfulness and so on, what is indisputable is that there's some equipment which is kept at SARS as a result of this investigation. And from the point of view of the public protector, that's the equipment. We know that, let's assume for the purposes of this chair that the unit was lawful and properly well established and what have you. So the point we're making now is not about the lawfulness or unlawfulness of this, it's about the equipment, assuming it's a lawful unit and all that, yes. And the reason why I'm now presenting the second letter, Chair, is to avoid a repetition of this. Because when we presented this, then this letter was sent to you and to me and so on to say we were misrepresenting the position about the lawfulness of the unit and so on. So I just wanted to make it clear that that's not what we're doing. We are actually assuming that for the purposes of the current exercise that the unit was lawfully established. But we're simply saying the public protector's job was simply to say this equipment, where did it come from? As she would do to a municipality or whatever. It doesn't mean that municipality is unlawfully established. It's just saying, where did you get this equipment?
Is it where did they get that, or
how? So
irregularity of the procurement
yes.
issue? Is that the point
that's
you want
the
to
point.
drive?
That's the point, yeah.
Okay.
In other words, I want to insulate that point. It must not be muddled up with whether it's lawfully established or not. It's purely a PFMA issue. Thank you, Chair. So I was just being fair to Mr. Kiswetter to say, having displayed his letter, I must also acknowledge that he wrote another letter to query what we were implying.
The complete.
Yes.
Okay.
Yes. Thank you, Chair. And that letter was dated 29 July 2022, Chair. It's bundle L, item 1, and the date speaks for itself. The mere fact that it was 29 July 2022, it means we had already started here. Thank you. Okay, thank you. Thank you. I think the point
would have been in the response of the questions that arose from the 11th of July 2022.
Absolutely. To Mr. Van Lochenberg, yes. Thank you, Chair. Right. And you'll remember that we used that letter for 2 reasons. For the point that I've just made, but we also use it to say, even Mr. Kiswet refers to the thing as the so-called rogue unit. So there's nothing magical. That doesn't mean he thinks it's a rogue unit. It's just how it's referred to. So PP, I think Ms. Mkhwebane, and I stand corrected on this, Chair, because I know she said it to me when we were consulting, but whether she said it in the evidence, I stand corrected. But Ms. Mkhwebane confirmed that she was one of the people who had gone to do the inspection or the relocation, whatever is referred to in that letter, of the equipment. Can you confirm that?
Yes, I can confirm. I mean, she even testified here. That's
Okay.
what she said. She went there.
Yes. All right. Okay, fine.
Because
So
I couldn't go, and I then requested, I don't know whether she went with Mr. Mateboge, but I said, let them go and
supervise.
yes,
Yeah.
just oversee that particular process, because I genuinely, and I mean, by then I say, I believe that due to our investigation and finally they are implementing the remedial action, and is the same equipment which we independently got evidence that it was procured.
Right. All right, fine. Then, okay, hopefully then that's going to make us move as quickly as I predicted on this year. Now, can you then, I know you said we started at the end for reasons which will become clear now about your conclusions. Now let's start at the beginning. We go to 5.2, which is at page 40, Tshepo.
5.3,
5.3.
yes, 5.3. I think page 60.
60, yes. Right. Again, here you said the issues in dispute, and this was.
It was a response dated 5 February 2019. SARS referred me to the extract of the SARS Commission of Inquiry report. This is still referring me to the Nugent Commission report.
Yeah.
So now we are highlighting that members might unlawfully have acquired and used the equipment, all of which came later to be alleged. So then
Yes.
that's where I'm saying to the chairperson that even he said, I see no reason why SARS was and is not entitled to establish and operate a unit to gather intelligence on the illicit trades, which are also set in my observations. Whatever they are doing, they should then do it within their mandate. So he said, even covertly, within limits.
Yeah.
So I think that's what I was stressing based on that.
Yes. No, and in fact, you'll remember on the 9 points that I read out for the chairperson and the committee's attention from the judgment of Pakwa Che
Yes.
and others, that one of the things you are accused of is ignoring or overlooking the Nugent report.
Correct.
Now, if you read that passage, which again you rely on for the second time in your report, is that passage against what you're doing, or is it actually in support of what you're doing? In other words, why would you neglect something that supports you if it does?
You know, I was considering, you remember there was that question as well, rely, and I think Chairperson also wanted clarity on that yesterday. So this was the response of SARS. And I was still making sure that I incorporate in the report to show that I've listened to you, SARS, and indeed, this is what you are saying. But this is also agreeing with what I at the end, hence possibly the issue of making those observations, acknowledging that yes, Nugent, your terms of reference might have been different. You were not conducting an investigation, but it was a commission. But I do note that you also say, because it complements what I also said, he said even covertly within limits. So I think he was also acknowledging, unless then he would say otherwise. But I read it to mean that can be done, but it should be within limits.
Yes.
Because I also agree that we cannot leave criminals who are, you know, affecting the economy of the country, which if it benefits the poor and the marginalized, and to allow that people can do as they please. And we have SARS, which has a responsibility to deal with illicit trade within their mandate, and they do have investigative powers within their legislation. So that was the intention.
Yes.
And
so
it's not true that I ignored. I mean, if they read this report, it seems as if they never read this report.
Yes. Yeah, well, exactly. The three charges then say, going back to the paragraph 290 of the judgment that I read out earlier, she being you, also failed to engage with the findings made in the Nugent report. Where does that come from?
That's why I'm saying it's very concerning, because it then shows that the judges, the report was before them. Remember, also acknowledging that judges will adjudicate the matter based on all the documents before them. And indeed, the issue of the Rule 53, if they also applied their mind to the evidence before them, they would have seen that I clearly stated that this is what the Nugent report, or unless I was supposed to be, I don't know. Because the SARS Commission of Inquiry report is the Nugent report. And exactly this is what it says. So I was just wrongly accused by the three judges. And hence I'm saying as well, one of them, Judge Bakwa, was the former public protector, and I think he should have been at least checked what the report is saying. I mean, give himself some time to just go through the report, because even in my affidavit, I mentioned that this is the report. Yes, Nugent was not investigating, but yes, SARS informed us about the Nugent, and it's mentioned in the report.
Yes. Yes, thank you. All right. Well, I don't know. I thought you were even suggesting that maybe they didn't know that the report that is in the report, it's called by its proper name, as it were, which is the Commission of Inquiry into Tax Administration and Governance final report. Are you suggesting that maybe they didn't know that's the same thing as the new gen report?
Angazi, possibly, I don't know, but they should have asked maybe the my legal representation, because they were arguing the matter there. I was not there, and I think that's why I said to the chairperson when I took the stand that now at least is my opportunity to just clarify all these things. And, I hope they are also listening that this is all what we did. And we never had any ulterior motives. But I mentioned that, acknowledging that Nugent report, maybe we should have mentioned it, Nugent Commission, but I mean, I think they were doing they were appointed by SARS, hence we referred it to the commission, the SARS Commission of Inquiry.
Yeah. Anyway, all right. But anyway, your version is that you did engage with because really all they're saying you did not engage with it. They're not even saying you did not agree with it or you should have agreed with it. Or they're saying you just did not engage with it.
That's not true. And again, I'm showing that I'm respecting the response from SARS. I never just ignore it,
okay,
but I took it into consideration.
Right.
And worse is that focusing on what the public protector is actually all about. Compliance, respecting the law, making sure that you have this legislation. Are you acting within the bounds of that particular legislation and actually the Constitution? Because yes, you can do those, you can covertly listen to people's telephones, follow people, put cameras in their homes. But because you are investigating and you do it within the bounds of the law, where it's very clear that you cannot just do that without getting the authority from the judge to do that.
Yes. Anyway, okay, for the purposes of this committee, all of that, I think, is let me put it this way, the merits or demerits are not that important. Obviously, they're important as the underlying factual basis. But for the purposes of this commission, of this committee, what's important is whether the finding of bias against you should be relied on, if you get what I mean. And so that's what I want to comment on, so that we move on from this. If the finding of bias, according to this judgment, is based on, among other things, the fact that you did not engage with the Nugent Commission report, and you can demonstrate that you actually did, then would this committee then be entitled to just rubber stamp that finding if its factual basis is false?
And the committee should not rely on this, because now I'm showing the committee directly from my report and even showing the public. And I hope even, hence I'm saying the judges and even Minister Mkhwebane is listening, and they are seeing what I referred to. And there was no bias on the part of the investigators, because I will just boldly say that the investigator was having all the evidence, the investigator analyzed all the evidence. And when it was brought to me to append my signature, I was also happy that they have definitely incorporated their evidence and the response of SARS. And so I would then say to the committee, to the public, yes, here's the judgment. It was confirmed by the Constitutional Court. Even those justices, I hope they are also listening. But this is the report, which clearly states that we have acknowledged, we have mentioned, you were saying, it says, they are saying,
It's
just trying to get that word,
the first part, sorry, Chair.
is number,
So the first time you mention it, Sepa, if you can go to
no,
paragraph
I'm just saying
page
the
41,
41.
paragraph
Yes, I've mentioned
5.2.5.
under the recruitment.
No, under establishment. At
Understand.
first.
Yes.
Can you go to page 41, Sepa? That's where you actually refer to the thing in full, as the SARS referred me to the Commission of Inquiry into Tax Administration and Governance. Yes, and Governance final report. The report. That's why you say maybe you should have said the Nugent report.
Maybe,
Specifically under the heading, the so-called rogue unit. Another interesting heading by Charles Nugent. The so-called rogue unit.
Yes.
In which it stated, and then you put 3 paragraphs from that report.
Yes.
Yeah, and then again, when it deals with the equipment, which is, I think page
60.
60.
Yes.
Chairperson, at 5.3.1.
Yes, that's what I would say to the chairperson, committee members.
And this time you called it the SARS Commission of Inquiry. Again, as I say, I don't know, maybe again you should have called it the Nugent.
That's why I'm saying maybe I should have done that. Because it was there, I think, in all the documents which we have availed to the court. And if they say I've ignored the report, they should have read, because I think again, as a lesson to learn from all of us, or from, in fact, to all the judges out there, all those who will then be adjudicating on our reports. I hope you are getting something from this inquiry as well, because when we conduct investigations, that's how we do our investigations. And that's why I am even saying, when the matter is dealt with or a report is issued, they would understand that there are investigators who will go out there, conduct the investigations. But for them, again, pleading with them, because I remember when we were busy litigating, I would say to the legal counsels who are representing the institution, please make sure that your starting point is the report. You deal with the report so that you kind of bring the judges into acknowledging what we did and what happened in that particular matter. So even now, I think when you adjudicate any matter, just go read the report, understand why we came to a particular conclusion, because we check the facts, we check what the institution said, and then we come to the conclusion. And not only my conclusion out of the blue, but it's the conclusion which is based on the facts and the evidence before us and what the law is saying about that. So here on the issue of the equipments, the very same judge is saying, yes, they might have procured it, they should have, and even if they do that, but the fact of the matter is within limits.
Yeah.
Because we can't have a country which is just governed, or some institutions are just going all out to destroy people's lives and to, do things without any, consequence.
Yeah.
Like you have to, the law applies to all of us, because if you procure anything, if one municipality, one school, or anyone, because Section 217 of the Constitution is very clear that we should all comply to when we procure competitive bidding, but then it then refers to PFMA. And if you have any issue which you will need to procure, you need to indicate that, okay, possibly deviating, but it must be recorded. You must be transparent about it, how you procured it, why didn't you advertise that for competitive bidding. So it's just purely that. That's
Okay.
all what we do as public protector.
Thanks. And maybe for the sake of emphasis, and Chair, please forgive me again for deviating. Sorry. Yes. Yeah, deviating, I think is the right word, off ramping a bit, but it's also to make sure that we don't come back to all these 9 things again unnecessarily. If you go back to paragraph 290, that's the judgment of Bakwache and the others. Just so that we emphasize this point once and for all. We established that they were just factually wrong as to whether you engaged or not with the Nugent report. Then they say at Roman 4, thanks, Tsepo. That was quick, Tsepo, before I could. Thank you. I think Tsepo is beginning to know what I'm going to say before I say it. All right. Then it says the blatant dishonesty of the public protector. This is now another basis for, remember the 2 things that this committee is supposed to find against you in respect to this is that you are biased and dishonest. And the dishonesty is expressed as this. The blatant dishonesty of the public protector with regard to the OIGI report and her insistence on ordering the Minister of State Security to implement in totality a report that she has, according to the report, never seen. Now, where does that come from? Sorry, I can't ask the question better than that. Yeah. Where do you ever say in the report that you never saw the IGI report?
I think yesterday she also covered that ground.
Yes.
Unless you
But
wanted to repeat.
yes, not
that,
just for,
she did.
as I say, Chair, it's for the sake, I'm now doing it almost against those 9 things so that
Okay.
we tick them away, yeah.
Yes, well, I never said that. Again, reading the report, and I think the question I will still ask them, if they given an opportunity, that they can also come and give testimony and ask them, okay, you read the report, which paragraph did I say that? Because I think I indicated to the chairperson yesterday how I struggled writing to each and every person. They violated the very same constitution, because Minister Duba, Minister Dlodlo, I even wrote the letter to the president. There was no response. But then in my report, I was showing that all these people have tried to, ask them to assist. All of them violated Section 181(3) of the Constitution. They never assisted. And the 3 judges, if they can indicate which part of my report, because there's no paragraph. I mean, the committee chairperson and members of the committee, if you can read the report, there's no way where I mentioned that I said I've never seen the report. And I mean, the very same recording, which was played here, I indicated I have the report, there is this report, and we need to get it from the source, because again, showing that I cannot just take information, or I cannot take just some report which is delivered by whistleblowers. Yes, we rely on them. And I said, even newspapers, if there's something published, it's a lead for us. there's this report, I must go to the source of the drafter of that particular report.
Mhm.
And the drafter then indicated, never denied that there's no report. He acknowledged to Dr. Dintwe that, no, it's there, but then our law says we are not the custodian. Minister of State Security is the custodian. And it shows there are letters which are written, the content of those letters. So I don't know what's the use then of requesting Rule 53 when you are not even reading those documents and come to this conclusion.
Right. Okay, thank you, Chair. I'm coming back then to where we were, having disposed of those issues. You then this is 60. Can you just briefly take us through there was somebody called Clifford Collins, and you've referred to the 40 million estimate of the equipment. Where did all that, how was that evidence gathered? I think Ms. Mkhwebane did assist us on that, but just from your understanding of the amounts or the extent or the amount or extent of equipment that we're talking about here.
That's the point where the heading is saying, whilst conducting the investigation, whilst approaching SARS, while SARS and responding and not assisting us, there is this independently sourced information which was the on the 6th of October 2011, paragraph 5.3.3, an anti-corruption and security, Mr. Clifford Collins submitted a request for exemption from procurement processes in terms of Treasury Regulation 16A 6.4. So that's the exemption, with subject confidential exemption request to acquire specialized security solutions and services from the sole supplier, Escape Com Solutions. This information was nowhere, it was not provided by SARS, but it's documents and it's directly from the evidence we've acquired through other means to see that, okay, there was a request for exemption so that they can procure this equipment, because at first they were not acknowledging the fact that there's this particular equipment which was procured. And there was also a submission, if I can move to the next one, which SARS provided prior, because when we checked other documents which we, they independently acquired, there was an approval to expand the original TSS, in fact, Technical Security Support Services Agreement. And the submission served before EXCO, because those were the documents we had showing how SARS acquired the other technical security equipment, and the discussion of that submission at their EXCO. And the submission indicated that SARS had appointed these companies, AST Africa, iView, Protea Coin Groups, Gansa, Final Engineering, to provide the equipments. And then the BAC committee, bid adjudication committee minutes also was reflecting the approval to award the provisioning of technical security service contract for the South African Revenue Services on a national basis. Again, acknowledging that it's within SARS's mandate to do that. I think, Chairperson, I will still continue to say that was within their mandate to procure any equipment for their security, for securing their buildings, securing their systems and everything. So again, 5.3.8, that's where we got how much was spent to procure the equipment.
Okay.
From this Mr. Clifford Collins, who submitted a request for extension and variation order of order against the original contract. So there was already an existing contract. Our main aim again is give us the documentation, show us what you procured. But then I think the issue of not revealing this procurement was based on the acknowledgement as well that this is not the equipment we can buy within the mandate of SARS.
Yeah. All right. Can we go to 5.3.18? Just for the sake of emphasis.
Yes, 18, I have also noted that SARS failed to provide with all documents relating to the purchasing of equipment for the NRG, SPU, and CBCU. So remember, Chairperson, yesterday I indicated that there's various names which were used for the unit, acknowledging, and I think in the report, we've also mentioned that it changed from this name to this name to this name. And the main issue also is that maybe going to 5.3.15, where the exemption which was approved by Mr. Pillay in 2009, it was only relating to a limited amount of 1 million for a period of 1 year. I think this will link up to the evidence which was provided here, because I think, I don't know whether it's Mr. Pillay or Mr. Van Locherenbeek, who just said, no, it was just cameras which you can buy from, it's not a complicated, I think there was that evidence which was given here before this committee. No, simple cameras, and which were not costing, because that's what they say. But then now you've got this 1 million, you've got this 40 million. You have evidence that, but this equipment is a sophisticated equipment which can be used. I think we're still coming to that so that you can see what kind of equipments we have.
Thank you. Advocate Mbofu.
Thank you, Chair. Yes, I've taken you there deliberately because I want us to move to the responses of the implicated persons, and really, as it were, it's a shortcut that I want to almost propose. Do we really need to even go, if indeed you established, or if it cannot be disputed, what you say, that this institution and these persons simply refused to give you the paper trail for the equipment purchase and procurement, do we have to go any further than that? Isn't that on its own sufficient to establish your complaint about breach of section 181(3) of the Constitution, which is the failure to assist the public protector, but B, the inferential reasoning that you've just articulated now? What I'm saying is that if a public protector, auditor general, policeman, or whatever authority says, I want you to show me your driver's license, and you say, no, I'm not going to do it.
That's a challenge which one was facing, because there was that resistance to cooperate. And the main intention was to reveal and to dispel any, wrong information which is perpetuated out there. Remember, there was a stage where I also mentioned that, if it means there is this perpetuation that there is this unit which apparently is operating in a rogue manner, If SARS has information, they've procured things properly, they can account for how the equipment was procured, then I don't think there would be any challenges. But then unfortunately, they never cooperated. Hence, I had to include that information here in the report. So there was also 5.3.19 where we are still saying from independent evidence obtained is that the unit had an internal process of procuring goods for investigation purposes. So this unit, which was operating, it means it was not accountable to any person. It was just doing as they please. And we were trying to make sure that that is not happening. And this report's intention was to say, SARS, continue operating within your mandate, within the proper procurement processes. So again, constitutional democracy, supporting the very same democracy and contributing to each institution to operate within limits.
Right. Thanks. And therefore, then we can, as I say, short circuit this by just going straight to the responses that you received. And the first one is at page 65, which you got from Mr. Kodan.
Mr. Kodan, yes, responded. We requested an affidavit, or we subpoenaed an affidavit from him. In an affidavit dated 17 May 2019, Mr. Kodan stated that he had never in any way been involved in the procurement of intelligence equipment by the SARS for any of its investigative, we wanted to say investigative units.
Yes.
So this is contrary again to the memorandum which he wrote, which he was acknowledging that they need equipment, or they need this intrusive and penetrative equipments, and understanding that that is the mandate of state security agency. Hence, he wanted them to be beefed up.
Yeah.
And maybe on that point,
yes, Chair,
of just a clarity from the people. So what would be your understanding of the involvement? What would be your understanding of the involvement, so that you can, I want to be on the same page as you.
Yes.
Because you're correct. He would have written that memo to the former Minister of Finance. So my understanding would be maybe he's doing that on behalf of other people. So, but help me with that, the issue of involvement.
Yes.
Because in the affidavit, he declares that he's never been involved.
Yes.
And you are linking that on the basis that he's actually the initiator by writing this memorandum. So it is the involvement that we need to have a common understanding on.
Yes. Chair, if you allow me to just piggyback on your question, and in answering that question, bearing in mind that, again, we're talking about the PFMA compliance, and he was at that stage not a minister but the accounting officer. Thank you, Chair.
Yes, Chairperson. I think again, as the accounting officer, you might not be writing because acknowledging that you have the bid evaluation committee, bid adjudication committee, assisted by the CFO, you have the end user who's preparing all those, but who's the final accounting person? Is him, because he should have, well, why sign something like that and you send it to your executive authority and you say, we want to have equipment which can do this, which is good, because possibly they could see that these criminals are so sophisticated. But now why write an affidavit and say he had never in any way. So I think even qualifying it, because that's what he said.
No, that helps.
Yes,
Let's proceed.
Thank you very much, Chair. And then we go to the
Affidavit of Mr. Pillay.
Yes, the response of Mr. Pillay. Again, in a nutshell, I think the way we dealt with the Kodan one, where you demonstrate that what you thought of that response with the help of the chairperson's question. So you can also just with Mr. Pillay succinctly say, look, it was inadequate or adequate for this broad reasons. Yeah. Remember now again. We just spoke now with the chair, with the accounting officer. Now we're going almost further down to the operational people, yeah, such as Mr. Pillay. I mean, I know he was also a leader, but he was below Mr. Kodan. Yeah.
Yes, I would say Mr. Pillay, remember, is the preparer of the memo, and in public administration is we can say is the end user. So he's the one who responded and stated that the allegation was vague and therefore he could not answer. He submitted to me a list of equipment, which he stated was a PowerPoint presentation listing certain equipment submitted to the then Minister of State Security, Mr. David Mahlobo. That's what he said. He further stated that the SPU, NRG, and the Higher Risk Investigation Unit did not procure or utilize the listed equipment throughout its existence. Now he's acknowledging there is this list, but they couldn't provide. How did they procure this equipment? But again, public servants who don't understand that when we write this, or even the members of the executive, when you are held to account, I mean, hence, the judges were saying, I never gave them an opportunity. Yeah, in the report, they've responded. Secondly, the Public Protector Act, we're dealing with you as a public servant. We are not dealing with your attorney. We are not dealing with your legal representation. Public Protector Act is very clear, Section 7, subsection, I think 8. It's very clear that, yes, might assist you, but not represent you. So now you say this thing is vague. Instead of assisting and making sure that you put this matter to rest, it's very clear, because you should have been very upfront and say, this is how we procured it. Again, being the end user, because and at the DDG level or deputy commissioner at that level, you should have made sure that, you know what, just to put this matter to rest, Public Protector, here's the how we procured, the minutes of the BEC, BAC, which is Bid Evaluation Committee, Bid Adjudication Committee. Here are the approvals. After that memo, this is what we did, and this is how we acquired the equipment. But again, we realized that we shouldn't have, I mean, even this one, it's Chairperson, it's very clear that they were acknowledging that this is the equipment they cannot use. This is the equipment which belongs to state security agents. So this is also an acknowledgement that we have encroached on the mandate of SSA. And this is what we were purely checking, Tina. We were not saying, you know, you were wrong, but we were showing them that here, this is what your law is saying, PFMA is saying, you didn't follow it, and it's wrong. So there are people who must be held to account. There are those who just will do as they please.
Thank you.
Chair.
On that checking point, I want us to check T.
Okay. Okay. I just have one more question.
Go ahead.
Are you, PP, are you still okay? Can we just do one section?
Can we go for T, please?
Okay.
Stand up.
Thank you, PB.
T.
We'll take a 10-minute break for tea.
Thank you, Chair. Thank you, Chair.
You've been overruled.
Yes.
By both the chair.
By both the chair and the witness.
Thank you. Ready? Okay. Back and thank you. Back from T, we resume again. Over to you, Advocate Mpofu.
Thank you, Chair. Moving on to the next heading, which Chairperson you'll find at 5.4, page 71.
Got that?
Yes, that's the so-called recruitment issue. Okay, now I want us also to tackle this much the same way as the previous matter. I think by now we're all like public protectors here. So we know the drill, what should have happened against the prescripts and so on. Yeah. So,
which is very good.
Yes. Thank you, Chair. So now, again, at its simplest, here you are talking about the personnel, the people. Now we've spoken about the equipment. Now we're talking about the ones with flesh and blood. But it's much more the same drill, really, which is were those people procured or secured according to the prescripts. So please take us then to the approach that you took in relation to this, bearing in mind, Chair, that the peculiarity about this particular section is that it's common cause, I think, for everyone, that it was also, in a way, the subject matter of the 2014 complaint. But we'll come to that. Can you just take us through then what approach was taken by you and the team, PP?
Thank you, Chairperson. Chairperson, I just wanted to put the two paragraphs before we move to this number 4. Page 66, 5.3.25 and 5.3.26.
Sorry. Page 66. Oh, I see. It's just going back to the procurement issue.
Yes, because
Okay.
I also need to show that the list which was shown by Mr. Pillay, but as well the independently acquired information was showing that the equipment was kept at SARS premises and was the latest technical surveillance countermeasures equipment that could be utilized for video and audio recording, as well as tracking devices. So in the notice of disciplinary hearing of Mr. Pillay, the charges states the following. So we also then received that information because he was charged for the same matter. So he was charged for employing personnel with extensive military intelligence background to the unit, apparently exposed SARS financially and cost and endorsing an approved exorbitant expenditure in their recruitment and acquisition of equipment used by the unit without following SARS procurement policies and their legislation. So you solicited and acquired the following intelligence equipment for use by the unit. So that is, we had to blank that because I think we will just read that section which allows the public protector to use her discretion not to publish certain information. The 5th charge as well was there to establish and fund the special investigative unit. So this is what we dealt with, or which was before us as well, from the evidence which we acquired independently, but others, it was through the documents which were received from SARS. And then I think here we deal then with the law, Chairperson, which we need always to apply. the section 38, which is the responsibility of the accounting officer, how they should utilize state resources.
Sorry, just
Yes.
a minute. Yeah. Yes. Actually, I'm glad you took us back there. You remember that one point I wanted to squeeze in, but I was beaten by the vote. Yes, that was the point. It was chair, and I just want to preface it so that before the PP can carry on. That last point, I was going to take you to 5.3.27.
Yes.
And then in the light of the question from the chair and my question about Mr. Pillay, as to whether, shall we say, an accounting officer can wash their hands and say, it's got nothing to do with me. And that, yeah, that's how I wanted us to close that issue before moving to the next issue. So with that in mind, you can take us to 5.3.27.
Yes, 5.3.27, Chairperson, and whoever is listening as an accounting officer, this is your Bible, because it says the accounting officer for a department, trading entity, or constitutional institution that includes the CEO of the pipe protector must ensure that the department, trading entity, or constitutional institution has and maintains an effective, efficient, and transparent system of financial and risk management and internal control. 2, it was relating to something else. And then we say 3, an appropriate procurement and provisioning system, which is fair, equitable, transparent, competitive, and cost effective. This is taken directly from section 217 of the Constitution. And then as well, I will read the bolded part. Chairperson, I don't know whether you've picked any other thing, but the bolded part, Roman figure 2, or must I read the whole section?
I think just the bolded part.
Well, from the screen, everything is bolded. So
Oh,
it
okay.
might be different with you.
Yeah,
with
yeah,
HR.
yeah.
No.
Okay. Okay, prevent unauthorized, irregular, and fruitless and wasteful expenditure. It's still there, it's a Roman figure 2, towards the end. So it says to prevent unauthorized, irregular, and fruitless and wasteful expenditure and losses resulting from criminal conduct. So this relates then to what the accounting officer should do, not the executive authority. So we are not asking Minister Manuel here. So that's, I think, that to transport,
Chairperson's question.
yes, leading to what we're dealing with here. So then the next one deals with number G. On discovery of any unauthorized, irregular, or fruitless and wasteful expenditure, must immediately report in writing. And H, he must take effective and appropriate disciplinary steps against any official in the service of the department, trading entity, or constitutional institution. Then which we can jump to then almost the end there. Makes or permits an unauthorized expenditure, irregular expenditure, or fruitless or so as an accounting officer, this is what is expected from a person. So by then he was the accounting officer, and Mr. Pillay as well, under the responsibilities of the end user, and as the senior management position is obligated as well to ensure that the institution complies to this. Whatever they prepare, send to the accounting officer, this should be the case.
Thank you. No, I think then, yeah, that makes it clear. It goes both to the regulatory basis of your findings, but also to addressing the issue raised by the chairperson. Whether I think, would you agree that in a nutshell, Section 38 of the PFMA really, the words accounting officer must be taken literally, that you are the person, the buck stops with you. You have to account. So, and that's why I think one of the things you read is about taking people into disciplinary action. So either you account or hold those who report to you accountable. But you can't say it's got nothing to do with me.
I'm not involved in any way. So you should be accountable for that. And the next paragraph, Chairperson, deals with then also acknowledging that within the National Treasury prescripts, you can request for deviations. But as well, we need to have all the documents because you should then show proof. I think I mentioned the simple example of somebody who's appointed without qualifications. And I said, if your policy provides that the executive authority may give a condonation, then you've complied because your policy says so. But here, there was no documents which were shared with us. The next paragraph also deals with still, you can procure, because National Treasury Practice Note 8, as an accounting officer, you can also procure on an agency or emergency basis, but then you should have very practical and convincing reasons why such goods are procured on an emergency basis and why they are procured from a single source or service provider. So that is what we do as public protector. And Chairperson, I need to indicate that, again, repeating, this is a very good opportunity to also bring to the attention of accounting officer, public servants, because you need to learn from this. And I think as a side issue, sorry, Chairperson, that's why when we changed the face of the website of the public protector, I said to them, let's make it a point that we even group the various reports, to show EMIA reports, maladministration, undue delay, tender irregularities. And my vision was for students at the university, you visit our website, you're doing constitutional and administrative law, you can visit and see how we've applied the very same legislations practically. It's like kind of case law. So I think that's what was the intention. And when we come to a remedy, we are showing you that you violated this law and this law. Going forward as an accounting officer or any official, don't repeat the same thing. Yeah.
Good. Okay. Thank you very much. Then we can now then move
to the next one. Yes.
To the next one. Yes. And on this one, which is 5.4, the recruitment issue, I've made those introductory remarks, but I'd like you to just, again, for the sake of emphasis, you've made this point yesterday, you've made it even this morning, but if you can read 5.4.1 to indicate really what you are doing and what you are not doing, as it were.
Yes, and the common cause issues, again, it's things which they were not disputing. The fact of the matter is SARS recruited employees to work in the intelligence unit or that unit. The issue for my determination is whether in doing so, SARS followed proper recruitment policies.
Yes. So again, I think it makes it clear. Yeah. You're not interested as to where all those things. The question is whether they recruited according to the policies.
Yes.
Not so much who they recruited and so on.
Correct.
Okay. Right. Then the issues then I think another important issue, by the way, is the first 5.4.2, which basically shows that this unit went back in time.
Yes. Yes, and I think I mentioned that yesterday and even today earlier, Chairperson, that there's somewhere in the report where we capture the how this unit was changing from one name to another function, but the issue is the same mandate, the same equipments and the same modus operandi, but we will just show that. So yes, it's tracing back to 1998. And as continuously argued by the respondents in the matter, SARS established various units to improve investigative capacity, which is good, fine. And That's why we captured it here. The timeline of such rationale is summarized below. There was a memorandum which was directly from SARS. It's part of the documents by then Mr. Eric Nettling to the office of the acting commissioner. So indicating then how this unit has been changing from one unit to another. The first unit was created to address serious non-compliance, was the criminal investigation unit in 1999.
Yes. Can we jump that part? I think we just established that there was that memorandum, and I just want us to jump to the second memorandum, PP, which is at 5.4.4.1. That would be the one from Sipombo one, Miss Jean Ravele, or rather two, Miss Jean Ravele and Ivan Pillay, which is the one that seems to start to show that they wanted, if you like, to deviate from the policies here. And if you can read from the aim, which is on the following page, page 73.
Page 73. Yes. Chairperson. Yeah, but I think just remember me to mention something up there when I'm done with this.
To go back to that first memo.
Yes.
Okay, fine. Look, can we
Yes.
will remind you.
Yeah, the aim here was that the aim of this submission is to obtain approval for the appointment of personnel referred to below. These are external candidates. So then the recruitment process followed was informed by a broad range of factors, in particular by the need to adhere to security given the risk and dangers associated with the work and the need for operational effectiveness. Whilst posts were not advertised in the conventional manner, individuals identified as having the necessary competencies for the unit to operate were asked to submit their CVs to a panel of for interviewing. Such individuals are recruited from both SARS internally and in the relevant security sectors and have the following range of skills: intelligence, legal, accountants, and investigative skills.
Right. If you can, before you comment, just go to the following page, because I want to ask a question that covers all those. It says 52 people were interviewed and so on.
Yes.
But then the next, for me, the important one is the following paragraph, which is almost like an admission that there was a deviation. Because my next question will be whether that deviation was justified to you or not. Yeah.
Despite the fact that the recruitment did not follow the conventional procedures for recruitment in SARS, so they are acknowledging, it is submitted that this is because of the unique nature of organized revenue crimes unit and the environment that its members will be expected to operate under. Therefore, this also raised red flags that they knew that they wouldn't follow that. Fine, it's good. Yes, we need people to investigate so that we can deal with the tax crimes and illicit trade, but then have it in your policy. That's all, because you are allowed as a public institution, the public protector, anyone, to deviate from your policy, but indicate in the policy that where the special needs or we need people who have specialized skills to operate covertly within the mandate of SARS, we would then do a headhunting process, because you are allowed to do that. And you can then justify that you cannot just advertise because then it will be a public issue and you don't want to compromise the security of those people. Fine.
All right. Now, before we come back to your previous point, I just want to finish off this point by taking you to 5.4.4.3, where, again, going back to the discussion we had earlier about the PFMA and so on. This time, it looks like there is indication of the involvement of Mr. Mkhwebane as the accounting officer. So please take us to 5.4.3 on page 75.
So the memorandum was approved by Mr. Mkhwebane on the 11th of November 2002, in which he noted that such approval was subject to a discussion with Ivan et al. On the role functioning reporting. So here it shows that he was involved.
Good. All right. Okay. Now that we know that there was recruitment, there was self-confessed deviation from, it says, from the conventional procedures of recruitment in SARS, and that Mr. Mkhwebane actually gave his stamp of approval to this. Then comes the $1 million question. Was all this sufficiently justified to the PP, to the public protector, by documents, by policies, and so on, as you have told us repeatedly? That's ultimately the test.
So the issue here is, it shows that there was approval, but then the involvement of the accounting officer and the issue that the policies or processes were not adhered to. So I don't know whether I got your question right, but I think for me, it's also addressed by the next paragraph 5.4.4.4.
Okay, let's clarify that properly. Do you want to repeat that question?
Yes.
So that
Yes, Chair.
we don't do any guesswork.
Yes. No, thank you, Chair. No, I was saying, PP, maybe I put the question too broadly or clumsily, that if we take it as a fact now from what you've established, that A, there was some recruitment, B, by the admission of the writers of that memorandum, and I'm quoting directly from what they say, that recruitment did not follow the conventional procedures for recruitment in SARS. So that as a matter of fact. 3, the accounting officer in the name of Mr. Mkhwebane signed off on this one. So he couldn't this time say it has nothing to do with me. So we tick all those boxes. Now the question is, to justify all that, was the public protector supplied with policies that corresponded, that justified that, and in which case you tick the boxes and then say, well, as you said, you might have deviated, but here's a policy that actually allows the deviation, and therefore there's nothing wrong. That's the thrust of my question.
All right, yes, correct. Because in this instance, there was no policy or justification. I think we will also see when we go to the findings and where we serve the Section 7(9) notice, because that's where we were supposed to be provided with those. Here's the policy. What does it say? And that can be done. So the matter was going to be unsubstantiated if we had that evidence. We wouldn't have it as substantiated.
Yeah. And well, in fact, if you forgive me again, I'll do what I did with the previous one by jumping to the end, because I think that's where the answer lies. If you go to 5.4.28, which
Yes,
is your.
as you go there, she said you must remind her about.
Oh, yes,
something.
yes, yes.
Let's
Before-
start there and then
Yes,
go
yeah,
there.
otherwise we'll
No, I
forget.
just,
I'm now
yeah.
reminding you
Yeah.
Thank you, thank you.
what
Thank you,
the secret you are going to bring.
Yeah.
Yes.
That
No.
was in relation to the memorandum at
Page
of
71.
Mr. Neatling, yes, at
Mm.
page 71.
I just want to mention that there was another, the anti-corruption unit was also established in 1999.
Mm.
If my memory serves me well, I don't know whether this is the one or is this ACAS, which I just want to put on record. I think I remember Mr. Matabuko was asked about it
Yes,
by the evidence leaders, if I'm not mistaken. So just to reflect that there's this unit,
yeah,
which is currently known as Anti-Corruption and Security, and has as a responsibility the safeguarding of SARS personnel information and material, as well as the conduct of internal investigations where staff may have been involved in acts of criminality that harm SARS in its ability to execute its mandate. So I wonder whether that's the one the Mr. Matabuko was asked about. But then again,
Mm.
if that's the unit, but the fact of the matter is then the unit changed and it became more sophisticated,
Yes.
because hence we are saying it moved from one stage to another, to another, to another. And you see here the mandate was more of internally based, and of which I'm still saying, fine. That's what SARS was expected to do in any rate to protect its officials and staff. Yeah.
yeah.
Thank you, PP. Just before Advocate Mbofu proceeds, you can help us. There's somebody, I think he wants to come in. He's really looking at that through that door. So let's make it easy for him to be inside. We are Kob.
Thank you.
Thank you. Proceed, Advocate Mbofu.
Thank you, Chair.
you.
Chair, I know I'm not a witness here, but I can at least comment on what the PP is talking about now here. The anti-corruption unit of 1999, I hope that is not where the so-called rogue unit came from, because then it means I'm guilty as well. Because I was appointed by this parliament in that year to chair something called the National Anti-Corruption Forum,
Okay.
which among others had ministers, Manuel and others. And I think this is what we encouraged for entities to have their own anti-corruption units. So this would have been done in that mode, hopefully.
Maybe.
I hope it didn't then metamorphosize into the rogue unit. Yeah. But yes, no, I think that's, thank you, PP. That's important, because this then traces the statement which is made somewhere else, which we dealt with, that said this thing actually came back from, or rather emanated from the late 90s and so on.
Yes.
Okay, now I was then taking you to 5 point, to the conclusion. Apropos the question I asked earlier as to whether all those deviations were justified by documentation. 5.4.28, yes. So can you maybe in the mode of the last one, take us through those conclusions, and we'll come and sweep up any other issue, but knowing where it leads us to. Yeah.
5.4.28. Yes.
Oh.
So, sir, this is the conclusion.
Mm.
Again, chairperson, facts, law, application of law to facts, and the evidence before us. We came to the following conclusion. SARS failed to provide me with a policy that applied at the relevant period, regulating the transfer of staff within SARS branches.
Next
SARS further failed to provide me with a policy regulating the headhunting of staff for positions within SARS, for positions with SARS.
one.
3, the failure to advertise positions externally is a violation of Section 832 of the SARS recruitment and selection policy. So
Okay.
this shows that they had a SARS recruitment and selection policy, and the very same policy they violated. So that's all we were looking for. Nothing more, nothing less. The accusation that I'm attacking because I was labeled this person who affected, and some members were affected with their families, divorced, were killed, and just because of investigating and showing that you appointed people, I mean, and we are dealing with bodies here. Yes, they were appointed, but follow your policy.
Yes. And yeah, now, yeah, that's a question I'm asking almost rhetorically then, which is really aimed at the members of this committee. And if you can help us with the answer. Given what you've now just told us, the entity says itself in black and white, we have not followed our own policies. We have deviated. The accounting officer has signed against that deviation. You come as a public protector and say, well, okay, give me then the documentation that justified those deviations. And they don't give you those documents. What are you supposed to do as a public protector? What other conclusion can you come to?
Definitely, because we are an investigative body. We always have to find other means and ways to go to the root cause of the problem. And that reflected, the issue of disregarding the mandate of the institution, not assisting the public protector to do investigation. Again, it still go back to the very fact of violating Section 181 of the Constitution, because you are a public servant, and the Constitution, if we say we are a constitutional state and the Constitution applies to all of us, why not comply to that and assist this institution? So I think it was purely based on assisting us to conduct our investigation, and just forget about the accusations and the, because again, I said it yesterday, Chairperson, and since the beginning, that I have touched the untouchables, and who will always perpetuate this narration that this public protector is rogue. I was labeled that by one of the ministers. But the only thing we're doing with the officials, again, surely I think it's clear now that the investigation was conducted by the officials, and based on the evidence before them and what is expected, that's the finding we came to adopt, because we have this support of what information we have.
Yes, I guess what I'm getting at is, if because ultimately these are impeachment proceedings. So I'm trying to put it in a simple way, this question of saying, what is the duty of a public protector faced with these facts that we have just established now? Let's assume there was a deviation, there was employment of people without adhering to the policies. Then the accounting officer signed against that, and you asked for the policy that justifies that, and you are not given that policy, and then you find that this is fine. Isn't that when you should be impeached? Because what other, I'm trying to say, what other conclusion could you come to on these facts that we have now established?
No other conclusion. I mean, this is the conclusion which we've reached based on the evidence, based on the responses, based on the policy, which we had to independently, analyze, and not checking who's who, but we had to do this. Now the question is, if one is, okay, let's say it's not me, another public protector, actually not me, not even public protector, chairperson, the Auditor General. I mean, if she can sit here and you ask her, here's the situation, your audit, not even her, because there's a lot of auditors who are doing this. Any auditor will tell you, or any investigator of the public protector will tell you, this is wrong. You can't then behave like that, being an accounting officer, being a public servant, actually. Now I'm sitting here, I'm being impeached, or then I must be removed because of this report. Again, it goes back to the very same thing of saying, then it means other people must not be touched, must not be investigated. And again, it goes back to what the Chief Justice Mkhwebane in the Nkandla judgment, majority judgment, that, you know, you just find yourself in a situation where you investigate raw state power. Some people don't want to account, they don't want to be investigated. And how do you deal with something like this? Because if it comes to any other department or government official, or the DGs and CEOs and ministers and everyone, if we behave like this, what kind of a society are we creating? I mean, SARS being the very important institution in the country, we cannot allow something like this to go on. And as the public protector, we are there to help them, to lead and be compliant to the Constitution. So, and I will still call upon them. I'm left with how many months? 3-4 months. So whoever will be my successor, please cooperate with, please assist. The institution is there to make you shine. Well, I used to say, Chairperson, when I visit various provinces, that, you know, the public protector operates like a kidney. You'll never see the kidney, but if your kidney is healthy and it keeps you going, we are not praising the kidney, we're praising you as a person to say you take care of yourself. So we're just operating from behind to make you shine, because when you get a clean audit, when we say this institution is performing, you know, and the people are happy, service delivery is being delivered, it's because you are learning. I think Honorable Sukras was saying the issue of self-cleansing, because you should be using these reports to just self-cleanse and make sure that you comply. I think I'll still say to the commissioner currently at SARS, go back to the report, go through it, correct whatever has been happening. But unfortunately, I even heard that the very same members were paid some monies, apparently sorry money or something like that. Hence I'm saying I was not against these people. They were doing their work, they were employed, and I was not saying anything wrong with that, but I was just saying your employer didn't follow the policy to employ you.
Yeah. All right. You know, this is what Judge Bakwa and the other two judges had to say about this part. If you go to paragraph 211 of the judgment, Tsepo.
211.
Yeah, it starts at 211. We called it, I think, instead of the recruitment issue, we called it the employment issue in the actual court case here, but
yes.
it's the same issue.
Are you there, Ms. Mori? Okay.
Thank you. Let's start at at 213. That's just the one just before, the one 214 actually speaks to the point raised by the chairperson here. But let's start at 213, which, and check it for first, also for factual correction. They say the public protector implicates Minister Kodan and Mr. Pillay in participating in the recruitment process. She, however, limits Minister Kodan's participation to the recruitment of Mr. van Lochenberg. Minister Kodan is not implicated in the recruitment of any other employee of the unit. Is that, given what we've just spoken about his signature of that memorandum, is that correct?
It's not true. It's not true because I'm glad here the judges took the time to copy and paste our report. But if you then read the report, it's very clear that we have also mentioned the fact that Minister Kodan signed the memorandum. So it doesn't only refer to Mr. van Lochenberg.
Yeah.
It refers to any other employee. So now they are saying, I ignored that. But if a person has signed, and he even commented and said, can I discuss with the provider that discussed with Ivan?
Yes. All right. Okay, so that's, we can, well, not tick, cross that for factual correctness. Then this is the chairperson's point. It says, in response, Minister Kodan reiterates that he approved the establishment of the unit, but denies any involvement in the recruitment of staff for the unit. He points out that it is the responsibility of management of the unit to do so within the applicable legal regulatory framework and so on. He argues that he was responsible for any irregularities in the recruitment process merely because he approved the establishment of the unit is absurd. Okay, what do you have to say about that in light of his status as accounting officer?
Again, judges should know that the minister was investigated as the accounting officer. I think possibly, I don't know, possibly they thought I was investigating the Minister Kodan. Responsibility as SARS, as minister. No, he was the accounting officer. Anything which is signed, anything which is happening, the operations, the appointment of staff. I mean, as an accounting officer, Section 38 of the PFMA was very clear, because there were those paragraphs which I said, must I read them? Because it also says to you, management of resources of the institution. Resources will also include how you ensure, because when you employ people, you need to pay them. It goes back to the issue of how you utilize the resources, especially financial resources, to pay these individuals. So I don't know what's upset about us showing that he was the accounting officer, and the legal framework which we relied on to come to the conclusion.
Yeah. All right. Now, now, if you go to 5.4.31, that's your conclusion.
Of the...
Oh, I'm sorry, it's page 84. Remember, you read your first three conclusions and then we were commenting on that. Now, and then I just wanted us to complete the conclusions so that we don't jump back and forth here.
Okay.
31, yes. That would be, it's still under the heading conclusions.
Yeah, it's page
And yeah, it's particularly important. I'll put a question when you just finish reading. 5.4.31.
Okay, the denial of Mr. Kodani in his participation in the recruitment process of one or more of the unit's employees is outstanding. The Skakana report and the Jean Ravela dossier confirm that Mr. Kodani played a role in the recruitment of Mr. Van Locherenbeek.
Right. Now, okay, so this covers two things. One is about his denial of being involved in any of the employees, and say that's astounding. I think we've dealt with the reason for that because he had agreed to having signed the approval. And then the second issue you deal with is the fact that in the other report, in this Kakana report and the Jean Ravela dossier, he confirmed, or rather, those reports confirmed that Mr. Kodani played a role in the recruitment of Mr. Van Locherenbeek. Yeah. Now, if you go, then the judgment criticizing you for even that reference to the Skakana report on the basis that, quote unquote, it had been, I can't remember the expression now, widely discredited. Well, firstly, to your knowledge, was that report widely discredited? If so, by whom?
That's why during the investigation, there was no way where we had any reference to, or actually, yeah, we didn't know. I didn't know who discredited the report. And again, using it as a lead and getting the information that this report was done, was submitted to all the recommendations which were made by that report, ended up leading to the IGI report, which investigated the matter and dealt with the matter. So I didn't know who discredited the Skakana report.
Okay, well, to go back to the findings of bias and dishonesty, this is again another basis upon which the charges made those findings against you. So if or unless, let me say, the evidence leaders or anybody will be able to show that this Kakana report had been widely discredited, can the factual foundation of your alleged bias then be sustained?
Even if, let's say, they show us all the evidence that it was widely discredited, but I indicated that the report at that stage when we were investigating, we relied and we mentioned that there's this information, and the information, we didn't have any, and when they say widely, well, it means the whole country knew, it was reported all over, there was a judgment, it was reported, and when we conduct research, possibly even in Safli is reported that there's this judgment.
Now, let me assist you. It's not true that the Skakana report was widely discredited. So if I'm correct in that, and that's why I'm saying, unless the evidence leaders, of course, can prove me wrong. But if I'm correct that it's not true that when the attend comes, if for the purposes of my question, if it cannot be sustained, the statement that the Skakana report was widely discredited, can the committee rely on that to remove you from your office?
No, they can't. Well, I'm saying to the committee, you can't rely on that. Because these were various other sources which we relied on. I mean, relying on the policy of the SARS, relying on every other thing. We've mentioned this information because it was before us, and you can't just remove me based on that.
Yes. The second issue.
Chief, sorry.
Okay, can I just ask this question, please? Because I just don't want to lose my train of thought. Please, Chair. Yeah. And it might also assist Advocate Bauer's intervention. The second issue is this, before Advocate Bauer comes in, and which is also quite crucial. Let's assume for a minute, given all the evidence you've given us now about how you came to the conclusion on Mr. Gordon's involvement in recruitment, both of other employees or Mr. Van Lochenberg. So assume there was no such thing as the Sikhakhane report, it never existed. Would your conclusions on this be different?
It wouldn't, because hence I answered earlier that with the responses we received from SARS, with their policy not mentioning the issue of headhunting, the finding wouldn't have differed.
Okay.
I like to, well, when I say even if that's the case, that's you like to say that's the argument, but even if that was the case, it was not an issue of malice or, trying all out to deal with the people. So it was just purely looking into what the policy is saying. And we're not dealing with one individual here. We are dealing with a number of people who have been employed during that process for that particular unit.
Okay, just a pause.
Yes.
Advocate Bauer.
Yes, it's one thing when Advocate Mpofu asks the question and then he gives the answer, which is what happened. But besides that, can we just get the public protector to answer that question? The question was whether at the time the Sikhakhane report was widely discredited or not. And then the public protector didn't quite answer it, and the Advocate Mpofu gave the answer.
No, Chairperson, that's really ridiculous. I'm allowed to say to a witness, at the end of the thing, we will argue this and that and the other, and then answer. Well, that's what I said. I said it's not, the premise is that it's not correct that it was widely discredited. And I even said, you'll also probably argue that it was widely discredited. But assume for the purposes of this question that in that exchange, my view will prevail. And I'm sure you can ask the same question based on it's for the committee, not myself or the evidence leaders at the end of the day to decide who's right or who's wrong. Yeah, but I'm entitled to premise the question on the postulation that I'm going to argue for. Otherwise, I must argue the point now, which I'm not allowed to do. I'm simply saying, assume that there'll be no proof that the Sikhakhane report was widely discredited. If I'm right, if I'm wrong, I'm wrong. That's the end of that question. It will be worthless. But if I'm right, then I'm entitled to an answer.
The exact words, it's not true that the Sikhakhane report was widely discredited. And if that's true, it cannot be sustained that the Sikhakhane report was widely discredited. There was no premises of what Advocate Mpofu's put now. The point I'm trying to make, apart from what, I don't want to go back and forth on this, Advocate Mpofu. All I'm saying is, can the witness just answer the question so that we know what the witness's view was as to whether at the time the Sikhakhane report was widely discredited or not, as opposed to Advocate Mpofu's view.
Okay, if Chair, I will allow Advocate Mpofu to proceed, but I'm not sure if it was a question or it was a comment made.
It really was a premise, and Advocate Power is
but
just being unfair because she has cut out from that thing she's reading now. She's cut out the part where I say maybe the evidence leaders will
Okay.
establish the opposite.
All
No,
right.
I said it in the original question.
Okay. I'm trying to
All
give
right.
over
That's
to you.
fine,
I
Chair.
don't want the two of you to argue. You are still going to have arguments
Yeah.
later on, and if and you will respond in terms of the questions. But
Yeah.
if it's not going to be asked now,
Okay.
the question can be
No,
asked.
thank you. I'll rephrase it, Chair. Thank you.
Go ahead.
Yes, I think it's easier if we do it like that. Yeah. Assuming at a factual level, both your legal representatives and the evidence leaders will establish as a matter of fact whether or even as a matter of law, whether the Skakane report was widely discredited or not. Okay, so put that in mind. In other words, it's not common cause. Yeah, but I'm saying that now, assuming for a minute that there will be no such proof that it was widely discredited, would then the committee be entitled to rely on that basis, which is basis number 3, for the conclusion reached by the judges that they say we conclude, taking into account the following, a conclusion of bias is warranted? Then they list all those things. We've dealt with the one about, did you see the report? We've dealt with the one whether you fail to engage with the findings of the Nugent report. We're now dealing with this one about Skakane report having been widely discredited of their premises. Do you get the question, Pippi?
I do.
Yes, please answer.
Yes. I'm still saying I never knew that the Skakane report was discredited. We used the Skakane report like any other report which we had, and also showing that that was the evidence before us, and it was relating to the recruitment of all the employees.
Yes, thank you. Okay, which then covers my second question. In fact, let me do it like this, in fairness. Assume now that the opposite, assume that the evidence leaders will be able to establish that this Skakane report was widely discredited. Now, my next question was the Skakane report the basis for your conclusion, or were you referring to it in passing? Or in other words, that's why I was saying, just postulate there was no Skakane, there had never been such a thing. Would your conclusion on this recruitment issue have been different?
No, not at all.
Thank you.
Still be the same.
All right, thank you. I think that then covers it. Yeah. Thank you. Oops. All right, thanks. Let's then move on to well, maybe while we are at it, on the judge's premises for your alleged bias. One of them is that no, it's fine. It's not related to the topic we're dealing now. I was going to deal with the Sunday Times thing. Yeah. All right. All right, I must not allow myself to be deviated as well. Right, now, there is, all right, sorry. If you go to 5.4.4.2, and again, to save time, I'm not going to, I don't want us to go into the details, but also we don't want to put people's names up there. The one at 5.4.4.2, you'll see that there are 1, 2, 3, 4, 5, 6, 7, 8 persons who were now being were to be employed under this deviated regime.
Correct.
Yes, and without going through their names, the first one is Mr. Something Something, intelligence officer and forensic investigator at defense intelligence. That's their qualification.
Correct.
The next one is Mr. Something as well, formerly employed by the South African Secret Service. And the third one is
Correct.
also a male, directing staff at School of Intelligence in the Defense Force.
Okay.
And so it goes. The others are the kind of neutral qualifications. The one is an investigator. The other one is a forensic expert from Ernst & Young. Other one is an investigator and an auditor and forensic auditor.
Correct.
But yeah, just those three type, the senior people were identified there. In relation to the earlier question as to whether there was an intelligence, well, I think actually no, you don't have to answer that. I think it has now by now been acknowledged by everyone, including in this memoranda, that there was an intelligence element to this. I think the only thing that might be in dispute is whether that National Security Intelligence Act applied or didn't apply, technically speaking. All right, sorry, Chair.
I think we're still on the issue of the individuals who are employed, maybe on that issue.
Right.
What's critical is that the focus here was the recruitment policy.
Mhm.
The accounting officer followed the recruitment policy, irrespective of who came to
Yeah.
which conclusion, but more specifically as well, that we're dealing with a number of individuals, because you've read those individuals, page 74, 75, and there are also individuals from page 76 to, yes, in page 76
77,
to
yeah.
77,
Mhm.
different names. There are also individuals in page 78
8, yeah.
for members of the committee to take note. So now, out of those numbers, it's around what, 30, 40 people? Estimation, it's an estimation. So I'm blamed for 3 individuals, but specifically also for Mr. Johan van Lechorenbeck, who was the witness here. So it was relating to their appointment, to the policy, to the process which is followed. And that's all what this report was all about.
Right, okay.
And the fact that they were never called upon, these people, they were never even served with the Section 7(9) again, Chairperson. They were affected, not implicated.
All right, and then if we go to page 80, I just want to dispose of the issue, the specific issue of Mr. van Lochenberg. 5.4.13.
Yes.
Onwards, that's where you deal specifically with Mr. van Lochenberg. If you can read 5.4.13 and maybe go to 14 and then jump to 16.
Further evidence submitted indicates that Mr. van Lochenberg applied for employment at SARS on the 13th of January 1999 for the position of Assistant Director, National Special Investigations Subcomponent, Intelligence. He was appointed to the position of Head Special Operations on the 15th of June 2007.
Next.
SARS failed to provide the curriculum vitae of and recruitment documents pertaining to the appointment of all employees of the intelligence unit.
Okay.
16, Mr. Ravel stated that he was given the CV of Mr. Van Locherenbeek by Mr. Kodan. Mr. Kodan had received Mr. Van Locherenbeek's CV from Mr. Pillay when he was still at the South African Secret Service to screen and verify before he was interviewed by Mr. Andy Mutibe, manager, labor relations.
Okay. Next one.
Mr. Van Locherenbeek's CV demonstrated that he had done extensive work as a deep cover agent in both the SAPS and the SAP,
South African police is the apartheid one,
and the
then SAPS
SAP,
is the
yes.
current one.
He had worked for the South African Narcotics Bureau before joining crime intelligence gathering.
Right.
And Mr. Van Locherenbeek was offered a director's position, which he declined on the basis of the salary package being too much for him. He accepted the position of assistant director and was appointed as assistant director, special investigations. And then on the 15th of June, 2007, he was appointed to the position of head special operations. So that's the information which was gathered, or we've also noted and included in the report.
Right.
And it was in the section 7.9, this information.
Yes. And just to be clear, so that we don't mislead the committee, when you say Mr. Ravel stated, you did not interview Mr. Ravel.
That's correct.
Where did you source the information attributed to Mr. Ravel?
It was sourced by the investigators. Similar applies to the reports of Bosca Kanebo, the opinions of Abu Trenghoff. So that is all the information which was before us.
Yes, in fact, yes, Chair, sorry, it's easier to make the point I want to make if you go to 5.4.15, because maybe it might be I was jumping it to move on, not to dodge that point. So I think it's better that we just go there so that we qualify the source of Mr. Ravele's information.
Yes, that dossier, undated dossier, which the officials, the investigators were having, that Mr. Ravel, a former employee of SARS, stated that Mr. Van Locherenbeek joined SARS in 1998, whilst Mr. Ravel had been stationed at the office of the Deputy Commissioner.
Okay, good. Okay, so that's fine. All right. Now that, okay, we've got that out of the way, we can then go to Mr. Kotan's section 7.9 response to you on in respect of that of those issues. You find that at 5.4.20, yes.
5.4.20. This one, Chairperson, is still the first audit. It's still not yet the section 7.9.
Okay.
Yes, because we had to subpoena their affidavit.
All right.
In an affidavit dated 17 May 2019, Mr. Kodan denied having any involvement in the recruitment of the SARS investigation unit. However, he believed that the proper process was followed by SARS in the recruiting staff.
Okay, we don't have to comment on that. That's the same answer as before.
Yes.
All right. Then, as far as Mr. Pillay is concerned,
he also responded, argued that the public protector had already dealt with the allegation relating to the recruitment of staff. He was of the view that the matter had been finalized satisfactorily by the former public protector, Advocate Madonsela. He promised no further response to these allegations. It is indeed correct that the issue relating to the recruitment of staff for the intelligence unit had previously been investigated by my office, but the matter was finalized and signed off at the chief investigator level which means that I'm still able to review such report if the need arises, because it was relating to labor relations issues actually, more than the recruitment of those officials, because they were complaining about their issues, and then they ended up referring the matter to CCMA. But then also what was clear from that closing report was that because the matter involved the intelligence unit, then there was that issue. I think if you will go to that closing report sometime, that it was still the Skakane report recommended that IGI investigate. So there was still that particular process.
Okay, thanks. Okay, and look, again, you can educate us, because I think like Mr. Pillay, we would not know some of those inner workings. So what Mr. Pillay really, he was refusing, maybe I'm putting it too strongly. He was failing to respond to your question, and he was raising what we lawyers call like res judicata. He was basically saying, I don't have to answer this because it was finalized by Advocate Matoncel. Now, you are explaining to us that it doesn't work that way. Or maybe we could call it the principle of functus officio. But those are just Latin terms which simply mean that the issue can no longer be revisited. Yeah. Now you are explaining to us that that signing off had been done at chief investigator level.
Yes.
What, as I say, for those of us who don't know the inner workings of the Public Protector's Office, what is the significance of that? What would be the difference? Let's assume that it had been signed off by Advocate Matoncela, as opposed to a chief investigator. What difference does that make?
If it was signed by Advocate Matoncela, indeed, I would have been functus officio. I wouldn't have been able to review that particular report.
Right.
But then because it was signed at the chief investigator level, that's still what we can do internally. We have a policy, internal review policy, because sometimes there's closing reports which are done and the people complain that the matter has not been closed properly. I'm still prejudiced. Definitely that is escalated to me. And then actually, not only to me, a lot of them, I would say to the executive managers, you deal with them at your level. Let's say a province has closed the matter, or a chief investigator has closed the matter. In a proper span of operations, the executive manager, the supervisor of this chief investigator, should then look into all the evidence, check whether all the processes were followed. And if they feel that, no, you should reopen or, consider the following facts, then they will do that until the matter is clearly investigated.
Yeah.
So this was signed at a very low level.
Good.
And again, 5.4.24, I'm also acknowledging that, be noted that the issue pertaining to the intelligence unit was not dealt with at the time, as it was under investigation by the Office of the Inspector General of Intelligence.
Good.
So that's the main reason.
Yes. Okay. So basically, then there were two reasons. One was the level of the approval, which did not preclude your subsequent involvement.
Yes.
And you're saying, in any event, the intelligence unit issue had been, to the extent that it was not investigated, it was because it was before the IGI.
That's correct. And, another issue which public servants or those who are investigated don't understand, or we are investigating, they don't understand, is that when we have this, firstly, when we send you that first letter, be as open and transparent as possible. Don't just be dismissive and not want to cooperate with the institution, because Mr. Pillay was supposed to just tell us again, okay, yes, I responded to Madonsela. There is this file. And I suspect that it was when I also realized that apparently there's this report. Then I had to write emails and request stuff. Can I see this closing report? Who was the investigator? What does the file, what is in the file, to avoid a situation where one hand doesn't know what the other hand is doing. So hence I advised Mr. Matabucha and them, can you check that file? What is it saying? Send it to me. And then when I checked, okay, there's a lot of other information which is there. I think I mentioned, but there's this, and that information is directly from SARS. It means they were cooperating with my predecessor more than me. So we could have said to, and we captured it like this in the section 7.9. Okay, now the second audit. Because then if Mr. Pillay indeed read this section 7.9, he would have said, no, PP, you are not correct here. And this is the true, it's what yes, we received that. But then, okay, on second thought, let me help you. This is the information on the matter. This is what transpired on the matter. But it's just that he just treated the institution with that, you know, I can't, it has been dealt with, therefore I won't entertain this. I think even with the issue of the equipments, he just said, no, I think it's the equipments where he said, or it's the operations, where he said, no, I'm still in court. Somewhere, he was that dismissive. So, yeah.
No, that's, well, you've preempted my next question. And I see that it's almost lunchtime, but if the chair allows me to ask this, just to a couple of questions, just to so that we round off this issue as well, so that we can move to something.
Please go ahead.
Yes, after lunch we can move to something else here. Okay, I'll ask this. Let's start with what you've just answered. As I've said, Mr. Pillay or any lay person like all of us who would not be familiar with how the office works would be entitled to say, well, this was done, therefore don't bother me. Now, my question is, and you're saying this was at the level even before the 7.9. Once it was pointed out to him that that's not a valid defense, let me put it that way. Was he then forthcoming with the information?
No, he was not. I think when we go to the findings and incorporating his response to a section 7.9, it will be very clear as well that he was still not interested in helping.
Okay, so
just before you proceed, Advocate Bauer.
Maybe Advocate Bauer can give us this after lunch, the reference in the 7.9 where it was said to Mr. Pillay that wasn't a valid defense.
Well, I don't know. I don't work at the Public Protector's Office. The
proposition, sorry, Advocate Bauer, the proposition that was put to the witness was when you indicated to Mr. Pillay that this wasn't a valid defense, was he forthcoming? So I'm asking the question as to, he didn't lay the foundation as to, I'm assuming from what followed that it was in the section 7.9.
All right, I think the witness actually covered this. Yeah, in the just now, a few minutes ago, okay, let me do it bit by bit. So this was then the response of Mr. Pillay to this.
Can you just quickly respond to that?
Yes, I am, Chair. Sorry, Chair, I didn't indicate. Yeah, when I'm doing it, I'm actually trying to deal with that. Yeah, but by through the witness. Yeah, you've said that this was an Audi opportunity, which was prior to the section 7.9 notice, correct? Yes. Now,
Yes, where there are affidavits, and again, I explained that they were sent subpoenas to provide notices.
yes,
And in the response to the subpoena, he indicated the following. So I thought we're still going to also the issue of responding to a Section 79. Because yes, not being convinced by the response, then hence the final conclusion on this matter as is.
no, I think Advocate Power's problem is a different one.
Oh,
I'm saying, let's just cut this to the chase. I've said, you asked for the information from Mr. Pillay, right?
correct.
He says, I don't have to answer you because it was done through Advocate Matoncel, correct? Yeah. You've now told the committee here that that's not a good enough answer because it was done at chief investigator level.
Correct.
In the next round of engagement with Mr. Pillay, did you point out that that answer it doesn't hold water, or did you did you insist on getting the information, and did you maybe let's break it down. Did you require the information again, and did you point out to him that this was not an answer?
I think let's go to the Section 7.9.
Right.
Because the information was captured in the Section 7.9.
Yes.
So to see how we crafted it in the Section 7.9.
Yes. All right. In fact, yeah, you're quite right. Chair, can we do that when we get back? You'll remember, Chair, that that Section 7.9 is that I think 71-page document that I went through in detail with Ms. Mkhwebane. And actually, that's the reason I didn't want to go there now, because it would be a waste of time. We went through it almost half a day with Ms. Mkhwebane. So we will refer to that document over lunch to point out where this point is dealt with here. Thank you, Chair.
Okay, and you done with the other points that you wanted before there was intervention?
No, sorry, Chair. There was just one more, just so that we start on something new and come back.
Yes.
Yeah, sorry, just one. I've just lost my train of thought now. One second, Chair. Right. Okay. Now, I just wanted to round off or to connect this issue of the IGI report. Just for the sake of completion, I think you established, you did say yesterday and somewhere earlier in the report that the IGI investigation, as it were, was an offshoot of Sikakan, because it looks like it was Sikakan who referred those issues for investigation by the IGI. Is that the correct understanding of the sequence of these reports?
Yes.
So in other words, we would have had Sikakane, IGI, KPMG by Moyane, and Nugent somewhere around 2018, I think. That's the kind of progression. Am I right?
Yes, I think that's what we incorporated, I think, in the report somewhere where It was the recommendations of Skakane to refer the matter to state IGI for investigation, because if it relates, and hence there are some instances indeed ourselves where if there's matters which relates to state security and how the officials they are conducting themselves, it will refer the matter to IGI. Like what I said about other ombudsmen, sector ombudsmen, because there are those sector ombudsmen who can deal with the matter. For instance, the SARS ombudsman. And then once that is dealt with, at least they are within that field. So yes, I think that's one of the recommendations. We've captured it in the report, if I'm not mistaken. What was recommended?
Yes. Okay. Chair, we can stop now. I'll start with the operations issue, but something tells me that there's one more issue which has just escaped. So if I need to sweep up one or two questions when we come back, then I'll do so.
Okay, thank you.
Thank you.
We'll now take lunch and be back at 2. We're adjourned. Thank you for lunch.
Thank you.
Recording stopped.
hand over immediately to Advocate Mpofu.
Okay, thank you. Chair, can I just defer this question we were busy with? I've got the section 7.9 of Mr. Pillay, the 71 page number, but I've not yet found. So if you can just defer, maybe we'll do it after tea.
No problem.
Yes, thank you, Chair. So 743 of what? No, I've got, yes, it is what, no, I've found it, but it's paragraph. 14.3, 125.
And 26, apparently.
Okay, I've got it. Thank you, Chair. Thank you. You know, I've seen that. I'm looking for I'm looking for something else.
Okay.
Yeah. Thanks.
That's fine. Thanks, Advocate Bauer.
That's just a reflection of the same thing that's in the report.
Thank you.
Word for word. Okay. The PP, let me just ask that question this way. Mr. Pillay, his okay, I was looking for the date of his 7.9. There are two issues that Mr. Pillay raised. One is that the matter was that you were from Tusofiki, and you've explained that could not help him. The second one is the issue of the IGI, that the reason why the matter had not, in fact, even been investigated by in the Matonsela regime was because it was at that stage in front of the IGI.
Yes.
Now, do you know if at this stage the IGI report had been finalized? At the stage of your investigation now, obviously it was. We know that the IGI report was issued out in 2014 already.
Correct.
Right. So again, maybe I should ask the same question. Was that brought to his attention that both of the issues that he was raising were held no water, and therefore he should still supply the information? To your knowledge, if you can remember.
I don't. That's how we conduct the investigation. Is we requested the affidavit provide us with all the information, because in the affidavit we are saying it's a document request letter. Everything, tell us what you know, and these are the issues we are investigating. And then after that, we analyze the evidence. They analyze the evidence. Then we issue a section 7.9, where we still say to the person, this matter is substantiated. And then we send it to the implicated parties, and it's for the implicated parties to indicate whether they still are disputing whatever is in the section 7.9. And that's what transpired in this particular process. So the section 7.9, as we're still going to go through it, whether also on the IGI report, where did I mention that it was just dropped, that IGI report in the office? I think if whether that was captured in the section 7.9, we'll have to see what information was there. But the process was purely a fact-finding process, because our investigations are inquisitive in nature. We are not investigating because we want to find people guilty or they are accusatorial in nature.
Yeah, okay. No, I understand that as a general statement. I'm asking the specific question, and if you can't remember, it's fine. We'll look for the information. Remember, Advocate Bauer's concern that she raised is whether, I prefaced this by saying we can excuse Mr. Pillay for raising those issues because, like all of us, we don't know the inner workings of the Public Protector's Office. So we might not have known necessarily that if something had been dealt with by a chief investigator, you in any event still have a power to review it.
Okay.
So we therefore can't blame Mr. Pillay for holding that view. Neither can we blame him if he held that view for the rest of his life, unless somebody pointed it out to him that that view is baseless. And that's really what I'm looking for, as to whether at any stage in the subsequent Audi engagements, whether it was 7-9 or whatever with his lawyers or whatever engagement, whether you insisted in getting the information on the basis that the technical defenses that he had raised were baseless.
No, I don't have any
Don't
information
remember.
to that
Okay.
effect. I don't remember whether
That's
that was done by the
Okay.
investigators.
No, that's fine. Then we'll have to give him the benefit of the doubt until we find if there was such an engagement, either by you or Ms. Mkhwebane or whoever.
Chair, sorry,
Sure.
So in other words, the question that you prefaced before the lunch adjournment, when you assumed that the deficiency in his response was put to him, is you withdrawing the question until you find the information.
I asked him, okay, so can
Question,
Ms.
sorry,
Ms.
Advocate.
Pillay, Ms.
Let me-
Fatima,
sorry, let
can she show me in?
Let me put it. The question was put when you pointed out the deficiency to Mr. Pillay. Did which position he took? None of the exact wording,
Yes, yeah.
right?
No,
And it presupposed that it was pointed out to Mr. Pillay.
Yes.
And that's the difficulty when we do the leading kind of thing, Advocate Mpofu. And so I question that, but the witness isn't able to tell us about that. And you think there's a reference in the documents. Can we agree that you withdraw the question until you find the reference in the documents?
no, I'm not withdrawing anything. Oh, sorry, Chair. No, I'm not. I don't know. It's a waste of time. I've just said, because of the objection that was raised, until we find in the, because I've just haven't had time now to go through the 7-9, we have to give Mr. Pillay the benefit of the doubt that nobody raised it with him. I can't do more than that. If it makes you happier to withdraw the question,
Well,
it's the same. I'll ask it again once I've got the information.
That's fine. That's
Yeah.
good enough.
All right. Okay.
Thank you. Proceed.
Thank you, sir. Now, so that was sorry. That was then the recruitment issue, and we understand it again in its two-legged way, that it relates on the one hand to the recruitment of Mr. van Lochenberg specifically, but it also is the recruitment of the rest of
All of them.
the people. Yes, okay. And if I understand you correctly, then you, insofar as Mr. Godan is the accounting officer, the buck stops with him for both.
Correct.
Yes, and as far as the rest of the staff is concerned, he signed on that deviation request.
Correct.
Subject, he said subject to having a discussion with Ivan.
I will ask the chairperson that we go to that part
Okay,
so that it's clear and
all right.
we
Let me,
don't have-
no, it's easy. It's very, we'll do it quickly. If you go to 5.4.4.3,
yes.
that's on page 75.
Mm,
That I understand to be the section that deals with all those multitudes, not necessarily Mr. Van Lochenberg. It's
correct,
all the other people.
correct.
And that is that deals with the 2002 memorandum of Mr. Mbongwa.
And
Mbongwa,
Mr. Ravel. Is it? Yes.
to Ravel and Pillay, yes.
Yes. And then chairperson, can I read actually going towards 5.5, 4.5?
Uh-huh.
Because Mr. Godan commented like this,
Mm.
and then 5.4.4, the functions, roles, and responsibility of the above mentioned unit from the evidence before me were either transferred to, or there was simply renaming of the unit which was named the customs, border control, SPU, SCBCU, and NRG, you know, I'm calling the C, the S chairperson, because in Russian a C is an S. So it is unclear what became of the employees that were appointed in 2002, as evidence indicate that the majority of the members did not form part of the CBCU formed in 2007. So there were new people appointed and whatever, but look at paragraph 5.4.5. In a response dated 26 August 2014, the very same issue which Mr. Pillay said, no, we responded to the former PP. And then where I said to the team, can you get that file? Why was it closed? But what is in that file? Because those are the documents of SARS and they are still valid documents. Mr. Pillay stated that the recruitment of employees into the Customs and Border Control Unit, who would later become members of the NRG, was approved in 2007. So that's when then Mr. Pillay, also there's a memorandum from him in 2007. He was the then General Manager of Enforcement and Risk of Mr. Makhashula, the then Chief Officer, Corporate Services, titled Specialized Capability to Focus on the Illicit Economy. So the need for the employment of resources that employees with specialized capabilities was outlined. So that memo was acquired from that file. So the recommendation of 26 candidates was supported by the COO. Hence the issue of Mr. Makhashula that he came back and said he doesn't know anything, whereas he approved this memorandum where they were appointing this team and with specialist knowledge on or to deal with illicit economy. So, Chairperson, this is what was transpired during the investigation, because remember, it's still the process of investigation. So we'll also have to check in the section 7.9, where is this captured? And when we were serving the section 7.9, what was the response to this? Because we were told that this matter was investigated and it was closed. Whereas for me, it was closed at the level of the chief investigator.
All right. Okay. No, I think that helps a lot, because again, and it might take us backwards in a way, but it would take us to the following place, whether even in the 2014 investigation, Mr. Pillay had actually answered this question satisfactorily. Because it would be no good for him to refer us to 2014 if the issue was left hanging even then, yeah. But for the purposes of the Advocate Power, we don't know that either. It's once we've gone to dig that far that we will be able to see whether he was whether this defense of his was well meant or just an excuse to not to answer the question.
Maybe let me say this, Chairperson, just to put this matter into perspective. he said in his response to the affidavit, no, I responded to Advocate Madonsela. And I'm saying it in the spirit of saying, if I was not there, it's an investigation which I received. There was nothing stopping him to say, PP, indeed it was, but then this is the information which I submitted. Or SARS, can you please give the public protector the documents which I shared with the Advocate Madonsela? That's all it is, because I'm saying, why the dismissive approach? No, this matter was dealt and it was closed. It's as if, why do they do that? Or I don't know what I'm supposed to be doing. It's purely on that. I was raising it based on that particular aspect.
All right. Can we do this, Chair, before I go to the next issue of operations here? Again, just to this juggling thing of referring to the 9 issues of the charges and our 6 pillars. Can I take you back to your statement, PP, just so that we can situate also these 2 exercises that we are doing at the same time, of dealing with the judgment and also dealing with the report here.
Okay.
Okay, so if you go to 144, Tsepo.
What's what you're looking for?
Page 144.
Okay. Page
Paragraph
144.
326.
What paragraph?
From 326.
Okay.
Right, let's just do 326 and just 326.
Okay. Must I read?
Yes, please.
As alluded above, the relevant charges against me which relate to this investigation and report are based on the adverse remarks made by the High Court in the matter of Pravin Jamnandas Godan versus the Public Protector and others, handed down on 7 December 2020, which already forms part of the papers.
Okay, so that's the judgment that we quoted from earlier, Chairperson. Okay, then you can jump to (329).
Okay. I have also considered the adverse remarks and findings made by Bakwa J. Some of his remarks and findings show a complete distortion of facts. It is on the basis of this distorted and objectively untrue facts that Bakwa J makes incorrect findings or conclusions of law, and I am going to demonstrate below how how Bakwa J incorrectly and impermissibly relied on distorted facts in his judgment on material issues. The original distortions came from Mr. Godan's affidavits. The refusal to call him as a witness to explain the distortions is therefore inexplicable. Actually, yes, the committee, because that's where it was going to be, the matters will be ventilated.
Yes, okay. Now that deals with 2 important topics, which I want us to deal with very quickly. The first one is, we dealt with that in the morning, that you are challenging the factual basis of the findings of the charges. Yes.
Yes.
Now, the second issue, which I think is more important, is that to the extent that one can excuse the judge's factual distortions, we can say, for example, where you say, where they say you ignored the Nugent report, which is just factually untrue.
Correct.
That they didn't just wake up and say that. It's because that's what was being alleged by Mr. Kotan in his affidavit. Maybe the fault of the judge is that they just didn't factually check. They didn't do a fact check on that allegation, but they did not invent it. It came from Mr. Kotan's affidavit. And you probably disputed it, but the judges just believed him for whatever reason.
Correct.
Right. Now, so that then takes us to the second issue, which is that the person to come and account for that mishap or misstatement of facts is not the judge, because the judge got it from somebody else. It's the originator of the allegation, of the wrong allegation, namely Mr. Kotan. And that's the issue then, which I'd like you to comment on, as to the refusal by the committee to call Mr. Kotan when the allegations upon which they are supposed to impeach you under this topic emanate from him.
Yes, I think the facts which the court relied on, especially his possibly pleadings in court and how he then presented the facts, maybe it was more convincing to them. And I think it also still makes sense for the committee to consider that information and evidence for him to come and explain, so that I can also clarify that the main purpose of that investigation was based on the fact that he was the accounting officer. He worked in that environment. He commented that, he's approving the unit, but then Mr. Pillay must talk to him. He was the originator of that memo where he wrote to the minister, which was prepared by Mr. Pillay. So I think it was going to be helpful to clarify all those issues to this particular committee, because currently I am presenting this side of my story, and the committee then it means must just take my version.
Yes, because you see, again, we should be fair to Mr. Kotan as well, because the first port of call should not be that he deliberately lied under oath. That's a possibility, but it can be the first port of call. The first port of call should be that he, for some reason or another, actually believed, for example, that in the report, you said you have never seen the IGI report. I mean, I don't know how he could make such a mistake, but let's give him the benefit of a doubt.
Yes.
So then if that was a mistake, which then somehow found itself, the mistake was perpetuated by the High Court, the SCA, and even the Constitutional Court.
Correct.
Without it being picked up.
Mm.
Then the person, as I said, to then explain how that mistake arose, if it's a mistake, or how the lie arose, if it's a lie, is not the courts, but Mr. Kotan.
Yes, they relied on the information which was before them, or they were convinced by his information.
Yeah, well, okay. Yeah, but they can be convinced about something that's not there in the report, that it is there.
Mkhwebane bona, they just believe that what he said in his affidavit, and they didn't go to the report and check for themselves.
Okay, that's fine. Somebody made a mistake somewhere at best, assuming the bona fides of everybody.
Yes.
Okay. All right. Okay, then you go on to, yeah, 330, please.
The allegation that I'm biased because during a public interview, I referred to the unit as the rogue unit gives the wrong impression that I coined the term rogue unit is not true, as Ms. Mkhwebane testified that the term was first used in the public domain in 2014 when the story of the SARS investigation unit broke out in the Sunday Times. The term was commonly and widely used in the public space by those who believe that the alleged existence of the unit was unlawful or rogue. This much is also stated in the relevant affidavit of Mr. van Locherenbeek.
Right. So shall we say then that's the fourth basis upon which the charges find you biased, is that you used the word rogue unit.
That's correct.
And so your response is that you used it in the same way as anyone else.
That's correct.
Okay. Now, Chair, we will. I won't go to this reference now because just to save time. But you might remember that when we were cross-examining Mr. van Locherenbeek, there was a reference to a speech that had been made by the public protector, and which became the subject matter of a lawyer's letter by Mr. van Locherenbeek. Yeah. And in that speech, you actually had referred to the thing as the so-called rogue unit.
That's correct.
In one part, and I think in another part as the rogue unit.
Correct.
Also, in the discussions that you had with Mrs.
Gavenda.
Gavenda,
Dr.
Bintwe,
Dintwe.
and the others,
Correct.
did the others, how do they refer to the unit?
In the transcript, or well, during the deliberations, I mean, the members of the committee listened to that. They were saying the rogue unit.
Yes. All right. And quite frankly, I don't know if anyone really can say that the use of that term in 4 or 5 years after its invention by the Sunday Times, I think everyone uses it that way. We just saw now that the SARS, the Nugent, Judge Nugent had a heading called the so-called rogue unit. Mr. Kiswetter referred to it as the so-called rogue unit. Yeah. So that would then be the fourth ground. And then you deal with one of those 4 grounds at 331. Can you, just for the sake of completion, read that out?
There is a misconception that I also ignored the Nugent report. However, the evidence of both Ms. Mkhwebane and Mr. Mataboge, which stands uncontested, is that we treated the Nugent report in the same way as we treated, we were supposed to say way as we treated all the other reports. The court also missed the point that the Nugent Commission had different terms of reference. He never found that the establishment of the rogue unit was lawful. He only expressed some doubts about some of the findings, which he said were not clear to him. And I think in the report, we've read what those issues were, and the issue of the rogue unit operating, which in fact not that unit should operate within limits.
Right, and yes, now 332.
On the KPMG and Skakane reports, I respond in the following manner. Firstly, I state that both the KPMG and the Skakane reports have not been reviewed and set aside. Having said that, I support the evidence of Ms. Mkhwebane and Mr. Mataboge, which again stands uncontested that as a matter of As a matter, the findings of both reports corroborated and made findings similar to the PPSA findings, which shows that the conclusions reached by the public protector's team were not outrageous or irrational. Further, both reports made a finding that the establishment of the intelligence unit without a mandate was unlawful and in contravention of Section 209 of the Constitution and the relevant statute. So it was purely focusing on those issues. So there was no way where actually we were indicating, I think we dealt with the issue of whether the discredit of the Skakane report and all those, because we dealt with it with an open mind and we were focusing on the contravention of the laws applicable to the operations or to the establishment of that unit.
Right. Okay, that's fine. Then to save time, I want at 333 you deal with the Judge Kroon issue. You've dealt with that. And then the IGI report, having seen it and so on, you deal with it at 334. We've already dealt with that. All right. So those will be then some of the, or rather, as we go along, we
And
will then
335, okay,
deal with the remaining grounds, the Sunday Times, the
okay.
this and that and the other. Yeah.
Yeah.
All right. Yes. Chairperson, we unfortunately, I need to raise an issue of concern. Well, firstly, we have noticed that for the first time since July that no members of parliament are present in this commission, in this committee. And it's a matter of concern, particularly given that you indicated to us that there was a view that the public protector, while she gives evidence, the committee had decided or proposed that she should be present here physically. So we don't know what's the point of her being here physically to address empty chairs. And it would probably.
Sorry. So where are we going now?
No, you'll see just now.
No, wait. I've not given you permission for that detour.
Okay.
I've not done that.
All right. I need to
I'm
raise.
still listening to you interacting with the witness.
Yes.
So you can't just do that.
All right.
And you know how we operate on issues that are not relevant to what we're dealing with.
Okay. Yes, no, Chair. This is not. This is a serious matter, and it's not irrelevant. And maybe of Kafan, if you allow me just to go straight then to the issue that I want to raise.
No, we can deal with that matter. I would want us to proceed with the issues that you are about to get into now. And I'm going to park that issue, we'll come to it, you'll raise it.
Chair,
I can't just in the middle of this and then that's what we do.
No, there's a reason,
No,
Chair.
no.
Please allow me.
No, I would not do that, Advocate Mbofu. I would want you to proceed and continue with the next pillar, as we call them, that you need to deal with. Because you shouldn't be getting into the issues that are of relevance to how I run this meeting as a chairperson.
No.
And I'm going to allow you to raise whatever issue you want to raise, but for now, I want us to continue to deal with the matter that we have been dealing with.
Yes. Chair, I hear you, Chair, but if you just hear me out, please.
No,
you'll understand.
No.
No, Chair. Okay.
No, Advocate Mbofu.
I can't continue, Chair.
No, there's no way you can continue. I want to continue. With the witnesses here, the committee is in session.
No, that's the point. The committee is not in session.
That's what you think. I'm going to explain that to you. Please go ahead with the next point, Advocate Mbofu.
Chairperson.
Because later on, if there's an issue that I must listen to,
Yeah.
I will do that.
No, sorry, Chair. It cannot be postponed. The issue is that there is no quorum in this meeting as we speak.
That's exactly the point, because you don't understand. I'll explain that to you later. because
No.
I don't know if you understand how we run these issues. I want you to continue doing that, and I'll explain that point because there's a quorum. Because I don't know how you understand the quorum.
Okay.
If you just pointing and counting people, then you're going to get it wrong. I'll explain that later. I want you to continue.
No, Chair.
If your issue is quorum, please continue.
Yes. No, Chair, no, Chair, I'm sorry.
Okay.
You have to, I'm ready to continue, Chair, but at least you have to convince me that there's a valid meeting. I can't continue.
There is a valid meeting, and I'll explain that.
No, I need to.
No, you can't do
We
that.
dispute that there's a
You
valid
can't,
meeting.
because you can't do that. Please don't delay this meeting.
No.
Because if a member, Honorable Lemisa, is not here, it can't be an issue that we must stop because a member is not here. I've not given you an opportunity for you to digress, to off-ramp. I'm the chairperson of this committee. The standing of this inquiry and this meeting, I remain in charge of that. And the decisions that we make in relation to what quorum and so on. You can't, in the middle of you interacting with the witness because you've just received a note, and that's what you do.
No.
No, I can't do that.
Chair,
I want you to continue interacting with the witness.
the problem, Chair, is that you don't want to listen to me.
I've already
You can't-
listened.
Yeah,
You've
but
raised what the
no,
issue
you
is,
haven't heard
and I'm
me.
saying I'm not entertaining the issue.
No, Chair, you have to listen to me and then you can overrule me. You can't.
I've already
refuse to
done
listen.
that.
You have-
I
No,
have
but you are
already
refusing to listen.
done that.
You are
And I'm
refusing
going to give you the last time to say
Please.
that, and I'll repeat my ruling.
Please, Chair, that's all really I'm asking for. You can then repeat your ruling. Chair, all I'm saying, I'm not fighting with you. I'm saying that according to our information, the meeting is not properly constituted. If we're right, we may be wrong. If we're right that the meeting is not properly constituted, then you can't force me to continue in a meeting that's not properly constituted. All that needs to happen is to make sure that we establish that fact, and maybe our way of establishing it is wrong. I'm prepared to hear that. But what you can't do, Chair, is then to force me to talk into a non-meeting. So I just
Thank
need
you.
to be, yeah. So that's all I'm saying, really.
Thank you, Advocate Mpofu. And you know that that's the role of the chairperson. It's not anybody else's role here to do that.
To check, yes.
So,
But to object is our
no,
role.
I'm going to come back to you and attend to that because that's when the point was raised, from about 2:30.
Yeah.
Not at a point when things would have changed. To say at that point, when you raise this issue, this would have been the situation, and I'll explain that.
Okay.
I'm not going to now digress from that. I want you to continue. I'll come back to that and explain that.
No, Chair. But then it means someone might go and recruit members. I want to know if there's a quorum now.
I've already given you the time at which I'm going to be telling you at this time, this is what was happening. There's no recruitment that is going to happen. I want you to continue advocating both and interact with the witness. And I see hands of the members. I'm not going to take those hands.
All right. Okay, we'll do that. But at least the record will show that we wanted a what you call it, a roll call or a check. But that's fine. If it's your meeting, it's your process. Okay. Now, the public protector, we're going to move to we've recorded the concern about whether the meeting is properly constituted. So we'll proceed as it were under protest or on the assumption that we are wrong on that score.
Proceed.
Right. The next issue was going to be the issue of operations,
Yes.
as the chair has indicated, which is whether the unit we've dealt with staff, equipment, establishment, and so on. Whether, assuming again the staff now, and this is Chairperson, the way we really would like this, we'll deal with it, I think, when we argue at the end. It's almost like all these are alternative grounds. So when we talk about the operations, for a minute, we have to assume that it was properly established, the people were properly recruited and so on. And we want to zoom into now the issue of whether its operations were rogue. Actually, this whole rogue unit thing is, if you think about it, it's only about the operations, because all the other stuff, whether the people were recruited badly or not, that's got nothing to do with rogueness.
So you're saying the establishment is less important?
No,
No,
I'm not saying that.
I thought that the 6 pillars
are all important. No, you're right, Chair.
Even if one pillar of those is
missing,
you have a problem.
No, fair enough. That's true, Chair. But I'm saying, just as a matter of fact, the loose term of rogue unit, which might even not be a good term, is really attached.
I do get your point about
the
importance you attach
of the
to operations in terms of their impact.
Yes,
Thank you.
And to the extent that the unit is named after the operations, Okay, good. Now, that being so, Madam Public Protector, the criticism, because always we must relate these things to the criticism, the charges, the judgments on which the charges are based, and so on. So otherwise we just talk in the air. So the criticism here is that, and I'm giving a broad brush, is that this unit was, doing the Lord's work, and there was nothing wrong with what it was doing. And you, in the pursuit of your agendas, relied on information, on dubious information, let's say, to come to the conclusion that its operations were illegal. You are aware of that. I'm putting it at its broadest. Yeah.
Correct.
Right. Now.
Sorry, Advocate Mkhwebane. Can we get some understanding as to what you mean by dubious? Are you referring to unlawful, or are you referring to? I'm just trying to figure it in the realm of legality. Where do we fit dubious?
Okay. Probably in. Okay, because I'm paraphrasing a view here. Yeah, I think maybe in fairness to that question, Chair, dubious in the sense that, and it will be clear now with my next question or two. You'll remember that some of the evidence comes from the confession, quote unquote, which was made to Mr. Mkhwebane by the members of the rogue unit. Mr. Duval and Lombard, there's already been evidence about that. So I don't think anyone says that did not happen, but then they'll say, okay, well, how did you know that that recording was authentic or whatever? So it's dubious. I use that word advisedly, because I don't think they say it's unlawful as such, but they probably say the weight, maybe the weight of the information is such that the public protector should not have taken it seriously. But it will become clear. But that's what I mean, Chair, by the questioning of the finding. Yeah.
Sorry, through you, Chair.
No.
Advocate Mkhwebane, is that the evidence you're referring to?
Pardon?
Is that the evidence you're referring to?
Which
The Val and Lombard evidence?
No. I'm making an example. You asked me why did I use the word. Remember, I'm paraphrasing what the criticism of the public protector's finding on this topic is. It's much more detailed than what I'm paraphrasing. All I'm saying is that its base, that criticism, is that the public protector, without talking to anyone from the unit, I think that's part of that criticism. Two, relying on dubious, questionable, whatever sources of information came to the conclusion that the operations of the unit were unlawful. And I'm just prefacing it. So I'm not. It's not me who says this. I'm trying to paraphrase the criticism of others, which obviously we don't agree with, so that we can deal with it here. All right. Anyway, there's no. In fact, we don't even need to go through all this. I'll take you to the judgment itself, actually, at the appropriate time. What it says about this particular aspect. But nevertheless, what is common cause is that you relied, Madam Public Protector, among other things, on the evidence which involved Mr. van Rensburg, I think at 5.34. This is what you say. The evidence before me indicates that during June, page 93. The evidence before me, is it there? 93, 5.34.
Put your mic on, Public Protector, your mic.
Of my affidavit.
No, I'm sorry, of the report, PP.
Okay. 5 point?
5.34, page 93.
Or we'll deal with the conclusions also.
Yeah. I'm just kind of jumping to that conclusion to deal with the issue that Advocate Bauer is raising. So I'm not doing what I was doing before of saying let's start with the conclusion. I'm just wanting to, because maybe I'm not articulating this the way you articulated it in your report. This is what you say, 5.5.34. The evidence before me indicates that during June 2007 until November 2007, Mr. Pillay and Mr. Janse van Rensburg irregularly recruited Mr. Helgard Lombard and Mr. Duval, and or authorized Mr. Lombard and Mr. Duval to intercept communication within the offices of the DSO, that's the old Scorpion, and those of the NPA, without an interception direction issued by a designated judge in terms of the regulation of interception of communication and provision of communication. So I'm saying that's your conclusion, that we can't escape that. But what I was then saying is that that conclusion is then criticized by others for the reasons that I mentioned. Do you understand?
Correct.
Right. All right. Now, if you can then, this one will start from the beginning, not from the end.
Okay.
If we go to 5.5.1, Tsepo, that's paragraph 84. Page 84, sorry. Okay, well, all right. So just for the record, Chairperson, I've been asked to, because of that issue that I raised, that our information was that at some stage there were 14 members, which and when there's supposed to be 19. I'm just placing it on the record. I'm not raising it.
This proceed was, I'm going to assist you later.
No,
Please proceed.
I will proceed, and I'll appreciate the assistance.
Thank you.
Okay. All right. We are at, yes, thank you, sir. All right. So take us this one. You've had the exchange between the chair and I about the relative importance of this of this section.
Yes.
And so I wanted to maybe quote unquote landscape it for us as to what materials you used, how you came to the conclusions about the operations, because after all, if this was a quote unquote rogue unit, it is its operations that South Africans out there should be worried about.
Yes, thanks, Chairperson. Again, this issue regarding whether the intelligence unit carried out irregular and unlawful operations, and if so, whether such conduct constitutes maladministration. Firstly, the facts before the public protector was that this unit, the way it operates in a way that it impacts and affects the characters, the livelihood, and the way they operate. They are not compliant to the law. So that was the focus of the public protector, because again, in this instance, the facts before me were that when we listened to the audios of the interviews conducted by the former SARS Commissioner, Mr. Moyane, interviewing these two individuals, Mr. Andries van Rensburg and Mr. Duval, in fact, Lombard and Mr. Duval, it was clear that the way this unit was operating was in such a way that it doesn't comply with the policy of SARS. It doesn't comply with the law, especially the SARS legislation and the constitution. And during the investigation, it was clear that, again, going back to the fact that my responsibilities were to make sure that I don't impact on the mandate of SARS. SARS must still continue to do the investigations according to their mandate. But then when listening to these audios, which I think we will have to, in a way, play a little bit so that you can hear, but we will deal with them. You'll hear that indeed it was the commissioner of SARS interviewing these individuals. They spoke about the operations of this unit, and if they were requested by NPA to install these cameras, the kind of information they collated, and they were part of the operations of the unit. So, and it was called Project Sunday Evenings, and where they would then listen. Even there are videos which were there. And I must indicate to you, Chairperson, that yes, we've captured this information here because it's what was based on the evidence, and it's something which we can submit. There was then another evidence which was there, where there were videos which were showing, after the installation of the cameras, what was happening within DSO, because they could watch the happenings and what is transpiring at DSO. Now it will come to the issue which we're still going to deal with, the issue of being accused of why entertain and matter, which is happened 2 years prior, why I shouldn't have I shouldn't have exercised my discretion to look into that, because of that information which was there and the allegations which were presented to me that the unit is still operational to this day. So that's what came to to our attention, and that's why we were investigating, and worse, also the kind of equipment which was utilized and how it was utilized without the approval of the judge, listening to the communication of individuals. So it was purely based on that. So,
Yeah, no, that's fine. If I can take the public protector to paragraph 336 of her statement, just to anchor this leg. Just a few typos, but I'll point them out when you get there. So, for example, it says NPO instead of the NPA. But
okay.
336. Thank you.
There was also ample evidence that Mr. Pillay irregularly instructed and or permitted a certain Mr. Lombard and Mr. Duval to intercept information or communication within the offices of the DSO and the NPA. I attached the uploaded audio recording of the interview between the two of them and the former commissioner for SARS, Mr. Tom Moyane. I am in the process of obtaining an affidavit which will confirm that he indeed participated in that recorded conversation.
Right. So, Chair, I'm now addressing you. You've heard what I've said about this before. Sorry, Chair, I need to refer to the. We have uploaded, Chair, an affidavit of Mr. Moyane, which was submitted in the Zondo Commission, which deals with this, Chair. It's a way of trying to circumvent two things. Either we can call Mr. Moyane or ask him to make a fresh affidavit, or well, we're in your hands. But we thought this is the most efficient way of trying to do this, with your permission, where he, as the public protector has indicated, that there's a long audio recording of this interview between Mr. Moyane and Mr. Duval and Mr. Lombard. It will just waste time to play the whole thing here. But that was uploaded a long time ago. What we then did to try and shorten this part of the proceedings was to secure the old affidavit of Mr. Moyane, where that same conversation is now in transcript in black and white, which will save members from having to transcribe it for themselves or for us to have to listen to it now. That's the shortcut, if there's no objection, which we are proposing. But the last point, Chair, that I want to make is that we're doing this in terms of the directives. Paragraph 7.2 of the directives of this committee says the committee may consider affidavits and evidence that have been filed in other proceedings and or before other bodies, provided that the evidence leaders and or public protector shall be permitted to put forward evidence and or submissions contextualizing the affidavits or evidence in question, and such is relevant to the motion before the committee. So I think the issue of relevance is clear because this emanates from the report, and these people's names are mentioned there. But it's just the procedural point. And if we read the directive properly, then the party who's proposing the importation of such an affidavit should then explain, be permitted to put forward that evidence and submissions contextualizing it. So we would like, Chair, it's already uploaded, but I can just go into it without passing this procedural step.
Let me check first with the evidence leaders, Advocate Bauer. Firstly, you are aware of this and what's...
No, I'm not, Chair. The last occasion when Mr. Advocate Mpofu sought to rely on these audio recordings, I objected on the basis that the audio recordings were hearsay, was one, and two, the issue was through the witness then and remains the case now is what verification was done of the audio recordings prior to the reliance thereon in the report. And that was the issue, not the substance of the recordings, but the verification done on the recordings prior to it being relied on in the report. Now, the issue remains that now it doesn't get remedied by an affidavit, which is done by one of the people involved in the conversation in whichever year. I presume it's post the report, Advocate Mpofu. The Moyane affidavit was done after the public protector issued her report.
Yeah, it was the Zondo Commission.
Yeah. So having gone back to the initial ground rules when Advocate Mpofu started about are we relying on information that emerged subsequent to the public protector having issued a report, and which matters we deal with in the course of that. This affidavit clearly falls in that category. It doesn't inform the motion or the charges because it happened after the fact. Now, I know Advocate Mpofu is trying to rely on the transcript attached to Mr. Moyane's affidavit in order to save time in having to listen to a recording. But all that the public protector had at the time was the recording. Now, I'm not suggesting that we accept that she had the recording. And if Advocate Mpofu wants to point to certain aspects of what was there, then so be it, but it still remains unreliable evidence even then, or information that wasn't even evidence.
So what are you putting forward?
I'm suggesting that if the chair is minded to want to use the transcript as opposed to the audio, my objections to the admission of it remains the same.
Okay, Chair.
Okay,
Yeah.
let me come back to you, Advocate Mpofu.
Yes, Chair, just in reply. Thank you, Chair. Yes, no, I think Advocate Bowers is maybe missing a few points here. She's correct, of course, that I said when we started, Chair, because I didn't want to be misunderstood when we were doing the so-called landscaping, that we're not here to appeal or rerun the investigation and so on. That's not what we're doing. What we're doing here, and I also disavowed, and I still do, relying on events that might have happened after the fact, for obvious reasons, because we have to situate the factual complex at a particular point in time. Yeah, but what I'm doing, Chair, is not to bring up some conversation that happened after the report. The conversation happened before the report. That's why they are referred to in the report. Yeah. And the recordings were listened by the public protector before she wrote the report. That's why they are referred there. All that has happened is that it's the same as the transcript of the meeting with the Inspector General and all that. If I happen to find it yesterday, I would bring it to you because it happened before the report was written. The fact that I only found it yesterday is neither here nor there. So that's really, I think, the point that is being missed here. All I'm doing now is as we've done right through, is to say to what I said we're all becoming public protectors now. To say what material was before the public protector when she did her report, and one of those materials was this recording. The only issue is really how do we then present it to this committee? Do we present it by going through with the public protector blow by blow what she saw in the, or what she had in the audio? Or do we play the audio here? Or do we do the practical thing that we are proposing, which is simply to put the transcript? But again, we can't just put the transcript. We're anchoring the transcript in the sense that it comes from an affidavit of one of the participants in that conversation. Could have been an affidavit of Mr. Duval or Mr. Helhart or whatever. But the only third person in the room was Mr. Moyane, and he presents it. So it's actually a matter of trying to find a way in an inquisitorial process of presenting this. I don't even want to go into the technicalities about hearsay and what have you, because that's not what we're about. And my understanding, Chair, is that when clause 7.2 of the directive was inserted, it was exactly for that. Because in court proceedings, this would never be allowed, that you bring affidavits and evidence that have been filed in other proceedings, provided the evidence leaders are permitted to put forward. But this was a way to facilitate. Otherwise, we have to go into the rules of evidence and call Judge Zondo to say, was this really served before him?
The public provider did raise a hand, so I need to listen to her first and then.
Sure.
Chairperson, can I give him 5 minutes stretch?
Oh,
I will assist as well
okay,
in this.
that's fine. We'll take just 5 minutes stretch. That's fine. Thank you.
Thanks, Chair.
Recording stopped.
The 5 minutes is done. Please close the door. It was 5 minutes. Stretch break. It was not tea break. Thank you. Thank you. I want us to
Recording in progress.
thanks, PP, for letting me there. Advocate Bauer.
Yeah, I initially understood Advocate Mpofu to say he was doing this because he wanted to rely on the transcript, but he's now clarified that he's seeking to rely on the affidavit and the transcript. I don't also see that the transcript has any authentication to it. I mean, I'm happy to say go through the transcript. I'm less happy about the affidavit, which I haven't really had a chance to look at, and whether it introduces material subject to the caveat I said to you earlier on that it wasn't there, and then say if there is a discrepancy between the transcript and the recording, I would then raise it later just to save time.
Okay.
The issue is the affidavit comes in a particular context.
That's fine.
In a
Thanks. I thought you wanted initially to deal with the transcript and
Yes,
place it. But
Chair,
even
I
that-
wanted,
So if we proceed in that way, so that I think your interest should be on the parts that are relevant to what we're doing, so that we don't get sidetracked by everything else that
Yes.
won't be in there. Maybe let me hear you out.
yes, Chair, if you hear me out, I'm trying to make a compromise here. The only reason I wanted to rely on the affidavit, Chair, is, well, firstly, obviously, to anchor the transcript. The second reason is that there's another document there, which is an annexure, and maybe let's do it step by step, Chair. Let's say we agree on the issue of the transcript with the proposal. And if I want to use anything other than that, I'll seek a further agreement. And I can, but let me play open cards by saying why I wanted to go further than the transcript. Obviously, there's a whole lot of evidence in the affidavit about all sorts of things that have nothing to do with you, with state capture and what. So I was not going to rely on that. But there are parts of the affidavit that talk to the transcript, number one. But there's another part where there's, which is only relevant to this committee, where there's, don't know what to call it. It's a complaint, police complaint by Mr. Moyane regarding whatever he received from these people. So I do seek to rely on that as well, but we can park whether that's also until Advocate Bauer has had a look, and if she doesn't object, then we will just indicate. But I won't go to war for the affidavit itself, because it was just to anchor the transcript there.
Okay, I think you should proceed. Advocate Mpofu.
Thanks. Okay.
We'll try and manage it together as
Yes.
we go through.
Thank you.
sorry, Chief, can I get clarification? Proceed on the transcript or proceed
Yes.
on? Do we understand that, Advocate Mpofu?
Yes, so I understand that the only agreement at this stage is about the transcript.
Sure.
I'm saying if we want to expand it
You'll raise
to
that.
what I've just mentioned, I'll engage
Yeah.
with you so that we don't waste time. If we agree, we agree. If we don't, the chair will rule. Yeah. Okay.
Thank you.
Thanks.
Proceed, Advocate Mpofu.
Thank you. All right. So after all that, I'm not going to use the transcript right now. I was just referring to the material that is that was before you, but we will go to the transcript. Okay.
Yes.
So all in all, okay, maybe I should ask you like this: how did you acquire the recordings that lead us to the transcript?
Some of the recordings we got from the whistleblower.
Mhm.
And I also wanted to say, Chairperson, before I ask for the 5 minutes break, that actually even I discussed the matter with Mr. Moyane,
Yes. Okay, good.
who confirmed to me that indeed that was the situation. And he has opened a criminal case about the matter.
Yes. Thank you.
So I'm
Yes.
just confirming that
Yes.
it was not hearsay, but it was a question of speaking directly with him as well.
No, that's fine. Okay, thank you. No, that part is resolved because if we called Mr. Moyane here, really, it would simply for him to say, where it says Tom Moyane, it's me. I think we've resolved that now, at least, yeah. Okay, otherwise he has no other role to play. Okay. Right. Now, and I then want you to please then take the committee to what you, without going to the transcript directly for now, what you understood to be the, I'll avoid using the word rogue, the unlawful activities or operations of the unit pertaining to the NPA and the Scorpions.
What was unlawful was that the issue of bugging the NPA and DSO offices in 2007. And that was done not as a way of following up with the issues of or tax related issues or what is within the mandate of SARS. In the information, it was that Mr. Herinel approached what Mr. Van Rensburg was saying, that he had received a telephone call of the personal assistant of Mr. Nel that they are requesting a meeting with him and indicated that NPA is having a problem with leaks and required a system that would help to record that. So Mr. Van Rensburg indicated that Mr. Nel did not inquire where he and Mr. Lombard work, as they never operated on official capacity as SARS. Mr. Van Rensburg, however, requested that he informs Mr. Pillay. So the involvement of Mr. Pillay came into the picture. Now Mr. Pillay was at SARS, operating at SARS, and Mr. Pillay then acceded to Mr. Nell's request that they go and install those.
Okay, sorry to interrupt you, PP. Just I see. I wanted just a synopsis, but since you are referring to the document, then let's refer the members to. You are now at paragraph 5.5.5.
Yes, Jeppe said I was still going to. I was just summarizing. I thought we will go through the.
Okay,
but
let's
the
do
main
that.
issue was that.
Just go to 5.5.3 and let's start.
Okay,
there.
yes. The main issue was that the operations led to one to wonder, are they operating within their prescripts? Yes, that's what one was looking at. Yes, and that's where 5.5.2, it says Mr. Van Rensburg submitted during an interview with the investigators working with Advocate Brasi SC. Information on the activities of the intelligence unit. The recording of that interview was made available to me as it would assist me in my investigation. In the recording, Mr. Van Rensburg discussed issues relating to the bugging of the NPA and DSO offices in 2007 by the SARS intelligence unit. So this is what, how it came about. Mr. Van Rensburg confirmed the existence of the unit and indicated that the operations of the unit at the time he was active within it were mostly kept undercover to a point where some of its employees did not have office space at SARS. Meetings to discuss current operations underway and to provide briefings to Mr. Pillay on current operations were in most cases held on Sundays, either at Mr. Pillay's residence or at a restaurant. The team members termed these meetings as Project Sunday Evenings. 5.5.4. In the recording, Mr. Van Rensburg outlined that he had received a telephone call from the personal assistant of Mr. Gerinel, whom at the time was a prosecutor at the NPA, requesting a meeting with him. At that meeting, Mr. Nel indicated that the NPA has been having a problem with leaks and required a system that would record. So Mr. Van Rensburg indicated that Mr. Nel did not inquire where he and Mr. Lombard worked, as they never operated as on official capacity as SARS officials. Mr. Van Rensburg did, however, indicate that he informed Mr. Pillay of Mr. Nel's request, which Mr. Pillay acceded to. So presentations of a recording system were made to Mr. Nel, who decided to approve the procurement of the recording system. The system was installed at the NPA after hours in the presence of Mr. Nel and or his personal assistant. The equipment installed was non-visible and remote, meaning that Mr. Nel, as the client, would have access to the system from home. Mr. Nel was also aware that Mr. Lombard would have access to the system for purposes of testing. So after a few months, Mr. Van Rensburg received a call from Mr. Pillay, who asked how far they were with the installation at the NPA offices and whether they could hear and see inside. Mr. Pillay informed Mr. Van Rensburg that he had authorization to see if the system can be used to obtain information on the Jackie Silibe case. Nothing was ever documented as they operated a gentleman's agreement. Mr. Van Rensburg had then instructed Mr. Lombard to record the information on the Jackie Silibe case.
Okay.
So again, this raised eyebrows, gentleman's agreement, and this relates to a state institution and the installations which were there. How were they programmed? So it goes back to all those issues that we should be operating within the prescripts of the law.
Okay, thank you. All right. All right, so you indicated the, all right, maybe let me ask it the other way around. Was there any indication that the alleged bagging of the NPA offices or even the Scorpions offices was in pursuit of anything to do with SARS?
Not at all, because here they are saying because they had leaks within the NPA and they wanted to make sure that that is stopped, or they would see what is happening at NPA.
Yes.
Hence my issue that then it raised those questions.
Yes.
What is NPA? Why? I mean, if you are SARS, you are investigating illicit trade, tax related matters. Now you have a senior official of SARS allowing something like this to happen at another state institution.
Yes. Yes, because in fact, this is the point that we'll come to, I think, when we get to the conclusions that I was making to the chair when we started, that the rogueness or non-rogueness of the unit is really about this kind of thing. So whether it was chasing tax dodgers as alleged, or now was just like a private army or intelligence force, not accountable to anybody. Now, if maybe what we should do, Chair, if you can be patient with us, is to go through the next section, which is headed information regarding Mr. Helgar Lombard and Mr. Johan de Waal. Because if we do that extensively as to how we may not even have to rely on the transcript. And so I'll just confirm with the public protector later if that comes from the transcripts, and then there'll be minimal reference to those. Okay, can we go to 5.5.9 and just read that whole section? And you can pause whenever you want to pause to comment, but so we just want to put it on the record.
So this one was also another recording where Mr. Lombard and de Waal submitted during the interview with the former commissioner of SARS. So that's the one where I said I confirmed with Mr. Moyane, and Mr. Mkhwebane was also there on the unit's activities. So in the recordings, Mr. Lombard and de Waal discussed the intelligence unit and certain operations they had participated in during its tenure. Mr. Lombard, with the assistance of Mr. de Waal, indicated that they had started in the unit in 2007 with Mr. van Rensburg as leader of a few operations. So in relation to the bagging of the DSO, Mr. Lombard stated that he had received a call from the Scorpions requesting for installation of certain equipments at the offices of the DSO. So he said the equipment installed included cameras, microphones, digital video recorder with routers, alarm systems, encrypted cell phones, and biometric access controls. After the installation, Mr. van Rensburg requested that Mr. Lombard listen in the conversation at the DSO. Mr. Lombard requested that Mr. van Rensburg obtain an approved section 127. So I think here it shows that Mr. Lombard knew that we should be operating within the law. So, and a couple of days later, Mr. van Rensburg informed Mr. Lombard that Mr. Pillay had received an approved section 127 from the former president, Mr. Mbeki, and therefore could begin listening to the conversation of the DSO.
Okay, let's pause there.
Yes.
We established when we were dealing with the prescripts that for a shortcut, for you to do some of this kind of interception, you need a permission from a judge.
Correct.
So then for the information at your disposal was that Mr. Pillay then told Mr. Lombard, and that also comes from the transcripts, that he had received permission from former President Thabo Mbeki, and therefore this was now legal. As to whether you could also get permission from a president, let's put that aside. But he represented that he had a permission from former President Thabo Mbeki.
Yes, that's what he said. And hence, when we investigate, this is the information we will collate, and then we'll have to test it against the legal prescripts. Therefore, when we were checking the prescript, which we had to rely on to test this, what is the approved section 127, but that should be the approval from the, in fact, in terms of that law, it's only the judge who can give a go ahead on that.
All right.
So that's what we had to check. But then again, this information, the question is, they proceeded whether to go ahead, and we couldn't even find this approved section 127.
Okay, good. All right, let's continue.
Then Mr. Lombard stated that Mr. van Rensburg had as reasons to listen to the conversations of the DSO, stated that Mr. Mbeki had been surprised by the arrest of Mr. Jackie Slibe Silebi. Mr. Lombard was therefore tasked to listen for anything that might surprise the president in the future. So that's what he said in that recording. And eventually, Mr. Pillay confirmed to Mr. Lombard that there had never been authorization for the listening of conversations at the DSO offices. So here you see Mr. Lombard listened to Mr. Van Rensburg. The communication was through this person. And this Van Rensburg was saying, Mr. Pillay said, let's listen to the communication there, and gave the approval for listening at the, in effect, for installation of this system. But now the system ended up listening to something else. And then Mr. Lombard is saying, no, Mr. Pillay confirmed. So that information, we placed it there for everyone to see that we've considered all, and we were truthful in what was captured in this information.
Okay, now, I keep on bringing you to this just so that we don't stray into the obvious political issues that are involved in this. From your point of view, as a public protector who's looking at the thing dispassionately, the issue then becomes, let's assume all this is true. Let's assume Mr. Pillay was told by Mr. Mbeki to back the NPA, which I doubt, and to listen, Mr. Lombard was to listen for anything that might surprise the president in the future, to avoid any further surprises from the NPA, as it were. Could that have anything to do with the stated intentions of the unit as a tax evasion busting unit?
Not at all. I mean, again, I still repeat that those were the red flags. And the question is, out of all the institutions, why do we have to install the cameras, and again with the approval of the SARS senior manager, Mr. Pillay? And if that is done, it should have been, actually, I don't know why Mr. Nell approached SARS to do that for them, because possibly if they wanted to do that, they've got their own policies. They should have also advertised, appointed a company properly to do this. So this information is just kept to indicate that this was the information which was out there, and we needed to test it against the available legal prescripts.
Okay, and then from 5.5.16, it would seem therefore that Mr. Pillay subsequently owned up that he had been lying, that he never had any authorization from President Mbeki, and he told Mr. Lombard that.
Yes, eventually Mr. Pillay confirmed to Mr. Lombard that there had never been authorization for the listening of conversations at the DSO offices.
Right. Okay, next.
Then Duval reiterated the above statements and stated that he was of the impression that the client, the person who wanted the recordings of the conversations at DSO, was the president and or Mr. Gordon. So that's the conclusion of the other person. But Mr. Duval further stated that there were other instances whereby covert intelligence was used to gather information on certain targets. And these included Mr. Mandisa Mkhwebane, Mr. Khatebe, the conversation between Glenn Atlioti, Paul Diloba, and Yusuf Kajer. These operations, he stated, were for the benefit of SARS and not politically motivated, like the bagging of the DSO offices. So you see, this was confirmed by Mr. Duval, who understood that the others, it was more related to tax and the operations of SARS. But this one, of the DSO was not at all the mandate of SARS.
Okay. Good. All right. So that's then the information that you have. And of course, as usual, you have to then put all these things to Mr. Pillay, Mr. Mahashula, Mr. Mkhwebane, so that then they can, to the extent that they are involved, well, maybe not Mr. Mahashula because he was not involved in this, but the other two. And so what were the responses? And that would take us to 5.5.19.
So again, we requested an affidavit from Mr. Mkhwebane. And here we brought the allegations, all the issues relating to the operations of this institution. And Mr. Mkhwebane denied that the unit operated in an unlawful manner. And if so, the members did so without his knowledge and approval. So that's what he said, which is what we considered, we captured here. Mr. Mkhwebane further stated specifically to the allegations of the bugging of the DSO and NPO offices that he was not aware, nor was he involved in any activities relating to the alleged bugging of the offices of the NPA and DSO.
Okay, now, thank you. So it looked from that response of Mr. Mkhwebane, then it looks like he was taking what we lawyers call the escape clause. Yeah. He was not saying this, all these sordid activities did not happen, or whether they happened, but he was saying if they did happen, it was without his knowledge and he was not aware. Now,
that's what his response
yes,
was. Yeah.
Fair enough. Now, from the point of view of an accounting officer, what would be the implications of that? Let's assume for a minute that it's true that he was not aware.
It goes back to the issue of oversight and management or accountability, because surely if the Mr. Pillay who reports to him was conducting all these operations and should report to the supervisor or somebody they report to. And I mean, taking into consideration that he wanted to discuss with Mr. Pillay on the appointment, the recruitment of these individuals. Again, taking into account that he in the beginning requested that SSA be funded to assist them, acknowledging that they can't do the penetrative and intrusive investigation. So, and understanding what the powers of or the investigation mandate of SARS. So surely he might have not been told, but I think if you have your executive meetings, you are briefed on everything. Surely he would have asked, what is the status of this unit? So I unfortunately, as the executive officer, accounting officer, the buck stops with you.
All right. But apart from that, to be fair to Mr. Mkhwebane again, apart from that official position, was it, and to distinguish Mr. Mkhwebane maybe from Mr. Pillay in this particular aspect, was it your case or your information or your finding or anything of the sort that Mr. Mkhwebane himself participated in the quote-unquote rogue activities, as opposed to the issue of the establishment of the unit and the signing on the personnel, which we have established as a matter of fact?
Not at all. I mean, there was no way, or there's no information which I had, which says Mr. Mkhwebane was participating in the operations of this unit.
Right, okay. Which then takes us to Mr. Pillay, who seems to have had his hands dirty there if the transcripts are to be believed.
Yes.
Now, what was his response to firstly, did he say he didn't know there's Lombard and Duval, or that they were not people who he ever worked with?
In his affidavit, he denied that the unit was involved in any unlawful and illegal activities on the part of SARS or its officials. And he never mentioned whether he doesn't know or he knows Mr. Van Rensburg, Mr. Lombard, and Mr. Divan. Yes. Now, again, here he then decided to say no. He further stated that he had been indicted for the allegations relating to the bugging of the DSO and the NPA offices, and therefore maintained his constitutionally guaranteed rights as an accused person, as set out in Section 35 of the Constitution.
Okay.
So then with that, we couldn't then get any further information from him on these, in fact, when he wrote to us originally, then when we go to the findings and their responses to Section 7.9, we'll also have to hear what was his response.
Yes.
Yes.
Okay. Well, yes, that's in America, they call it taking the fifth, which is a reference to the Fifth Amendment. So, and this, as I understand it, then this goes back to the question of then the non-calling of witnesses. You wanted Mr. Pillay to be called here to finish his evidence.
Correct.
And particularly because let's assume then that point he was taking the technical point that he was actually facing charges and therefore could not assist.
Yes.
He's no longer facing those charges now.
Correct.
So maybe he may have been able to assist us in this committee. But what is your comment on the fact that he was allowed not to come back? He said he was available for one day in September 2022, and that seems to be like that applies for the rest of his life.
I will plead with the committee to call him back so that he can clarify this point. Because now whatever I'm saying here, again, will stand. The allegations or what is said by Mr. Van Rensburg and Mr. Lombard and Duval. So it would help that he can also then tell us and clarify this information to the committee, that by us incorporating this, you are no longer then facing the criminal case. I think it was withdrawn. Then can you just take us through this issue?
Yes. Thank you, Chair. I've just asked for that document to be found, which is I think the charge sheet. But if there's no objection, before we find it, you would be aware that we previously put it up. I think don't know whether it was in the cross-examination of Mr. Van Lochenberg or Mr. Pillay. But that Mr. Van Lachenberg and Mr. Pillay were criminally charged together with Mr. Van Rensburg as a result of all of this.
Correct.
Yes. And that takes me to the issue that I had packed, but maybe let me try and avoid it, because in fairness, Ms. Power might not have had a look at that particular annexure. So I'll just refer to it without going into it. It's the annexure, the first annexure to Mr. Moyane's affidavit. And it's called what we put up earlier was the actual charge sheet, I think. This one says the statement of complaint, which then brought, someone goes to the police station, presumably before there's a charge sheet here. So it's the statement of complaint in order to satisfy my legal obligation to report allegations of corruption in compliance with PRECA.
Okay, is Tsepo
Oh yeah, it's page 929
of
of the attachments to the Moyane affidavit. I don't want to get to the body of the thing because
okay.
I must still negotiate with Ms. Power, but I'm just referring to
Chief.
it.
Yes,
This is-
Ms. Bao.
We had an arrangement about the transcript, and now you're going to another annex attached to the affidavit.
Yes. All right. Okay, I'm saying that's why I don't want to get into the body of the thing. That's exactly why I wanted the admission of this whole affidavit, because I don't want to have to do this in a piecemeal fashion. All right. Okay, it's fine. We'll do it some other time. But to your knowledge, are you aware that you may not know who laid the complaint or whatever, but you are aware that in this committee we have previously put up the charge sheet of those gentlemen, Mr.
I relied on that. We got the charge sheet through our investigations,
Yes.
and the information, I think it was part of the evidence which we've considered.
Yes.
It's just that we must get in the report, where did I refer to that evidence?
Yeah. Well, here it's even the part that we've just read now refers to it. Mr. Pillay told you that he's facing charges. Mr. Pillay told you that he's facing charges for
Relating to
bugging
the,
the DSO and
Correct.
NPA offices, and therefore he couldn't answer you because he was invoking Section 35 of the Constitution.
that's correct.
Yeah.
But I think, Chairperson, if I'm not mistaken, there was a time where we uploaded that charge sheet, and it was even showing the pictures of the equipment.
Yes, no, we did. There's no, I don't think there's no controversy about that. I'm just finding it.
Sorry,
The
Chief.
document was signed by an advocate, Pretorius. It's part of the record. What is new? The only thing that seems to be controversial is the complaint, the police complaint that led to that charge. So I'm leaving out the complaint now and talking about what is non-controversial, hopefully, which is the charge sheet.
Mm.
Right. Thank you.
Advocate Mpofu, I think it's part of the Rule 53 record, and we do have it, the charge sheet.
Yes.
The charge sheet is part of, to my recollection, it is part of the Rule 53 record, and it is here.
Yeah, that's exactly what I'm saying.
Okay,
I'm
go
saying,
ahead.
yeah,
That's
part-
where you were going.
Yes, that's where I was going, Chair. I was saying that that one is not, I thought what is being contested is whether I can refer to the police complaint that led to that charge sheet here. So I'm parking that for now. And really the the only point I want to make out of this is a very small one. It's not, I have no interest in the charges or non-charges of these people. And it is simply the fact that, you know, apart from all these other people, Kroon, Skakane, Nugent, what have you, that the NPA, at least at some point, also saw enough evidence for it to charge these people. I know that they were later withdrawn, but that at some point there was a view that there was sufficient prima facie evidence of criminal activity.
Correct.
Okay. All right. And so, as I said, we don't even have to put it up. It's just, that's the only fact I wanted us to establish, just as yet another independent body that took that view. Yeah. All right.
That's correct.
Good. Now, okay, with all of that, let's go to 5.5.27, if you can just jump. Sorry, I don't know if you answered my question about whether Mr. Pillay said, apart from taking this technical point about being charged, whether he said he did not have any dealings with Mr. Lombard and Mr. Duval, if you remember.
I don't think he did, but we will have to check his response or his affidavit. I
Okay.
don't think so, because if he did, we would have incorporated it here.
Yes, okay, good. So let's go to 5.5.27.
Yes, this was the what was in the file of complaint by Mr. Manike, who confirmed that, as Mr. Lombard stated, that the unit were instructed to track and take Mr. Leonard Khadebe's vehicle because he constantly visited Mr. Jacob Zuma. This information was found by tapping and intercepting Mr. Khadebe's phone.
Right. Okay, so, all right. Did you follow up on this? Who was this Mr. Khadebe? It looks like someone who was usually phoned or was phoning a former president. Was there any follow up on this particular information?
There was no follow-up, but the main thing was checking whether the operations were in compliance with the SARS operations, because remember, the other one said they backed the NPA offices, DSO, and the other one now is saying this Mr. Khatebe vehicle was tapped and the interception of his communication. Again, if you do that, you need to have the approval of the judge, and it should be relating to your mandate as SARS. But we never met with Mr. Khatebe.
Okay.
That's the information we've put out there. And that's the information we had to also include in the Section 7.9 notice, which we will have to also go through and see how was it responded to.
Right. Okay. And for what it's worth, did you then find that any of these people had any of the requisite legal right to do this in the form of, for example, the judge's order or permission?
That's the investigation then uncovered that those operations, if you take the evidence before us then, and if we go to 5.5.33 of the report, that's where we said the provisions of Section 3 of the Communications Act provides that communication may only be intercepted by authorized persons in execution of an interception direction. So an interception direction is an authorization issued by a designated judge on application to an applicant. So this chairperson, again, repeating over and over the operations of this unit, because if you then operate out of the law, normally we would say, some people will say, no, this is not a banana republic because anyone can do as they please. So we shouldn't encourage something like that. Hence, we are there as public protector to make sure that when a complaint is lodged, we investigate, we put all the evidence and information which is before us, and checking that if that has been done, is it within the prescripts of that institution? Even here, it was purely checking whether by intercepting and listening to people's conversations, yes, as SARS, you can do that, but it should be for your mandate. But again, you should comply to the law, as said by the Commissioner Nugent as well, that they can do that, but they must do that within limits.
Right. Okay, that then takes us to the conclusions which you reached, and you've already read the first one when I took you there to clarify the issue of the transcript. That was 5.534, so we don't have to read that again. So can we start at 5.535?
Yes, the conduct of the intelligence unit in the intercepting or private communications of individuals seriously violated their rights to privacy. The unlawful interception using state institutions and resources to fight personal and political battles amounts to abuse of power. So that is also still within the mandate of the public protector to investigate and the issue of abuse of power. Further, it is highly unfeasible that the unit's officials operated in isolation of their principles. I think we should have said principals, but
Okay.
yes, the unit was managed by Mr. Pillay, who at the time reported to Mr. Gordhan. So again, in public institutions, the way we operate is that anything you do as an official, that unit, you need to then escalate and report your operations. Possibly they also had meetings where there's an allegation up there that these operations were reported at this project Sunday or at Mr. Pillay's house. So that was the information which was mentioned, and that information again was included, or I think it was brought to their attention. We'll have to check what was their response on that.
All right. Now, I want to know then if at any other stage, Mr. Pillay dealt with or squarely, dealt with the issue of his being implicated directly as the mastermind or whatever role you want to say he played in the bugging of the NPA saga and claiming that he had the permission of the president and all that. I know that at that stage, he effectively avoided that question because it was sub judice or it was subject of pending charges. Has he ever denied in with some detail? I mean, either by saying he doesn't know these people, or they're just making it up, or they don't like him, or whatever. Has he ever dealt with it squarely?
In the report, there's no way where we captured it that he denied it. In fact, he denied the fact that the unit operated illegally. He didn't deny that I don't even know these people. And I never indicated that so and so operated this unit as per what they are saying. So I think, Chairperson, we will have to also then go through, but SC will take us through that, or because it was going to help as well for me for us to just show that these are their affidavits, these are their direct responses, and what they actually said in their responses. Because remember, I'm accused of not taking their information into consideration.
Yeah. All right. Okay, Chair, I was just looking against the judge's findings. All right, I think we've dealt with 4 of these here. Can we, before we move to the qualification issue, just maybe also deal with this thing of remember the first basis for alleging that you are biased is this issue of jurisdiction. I don't quite understand how that works here, but I suppose the allegation is that because you investigated something that is more than 2 years old, therefore you were overzealous, or you were chasing after these people, or something like that. But it's not quite clear. But I think we need to deal with it because it's put up actually as the first ground for your alleged bias.
Thank you, Chairperson. I think I hope we will then go into that in various in details, because that is the issue which led to being accused of being biased or targeting Mr. Gordhan. And yes, indeed, for us to go through the charge and the allegations that I was targeting him.
Sorry, let me just read it out. That's what the judge says. The judge is saying the investigation, your bias is warranted because of this. The investigation and the report fell outside
paragraph 290.
290 Roman 1.
Roman figure 1.
Yes.
Yes. Oh, I wanted to say, because in the investigation as well, how we conducted the investigation, sending the subpoena. I think we will also have to read the sections besides section 7, subsection 4, but section 7, subsection 1, or Roman figure 1, how to determine the investigation, the kind of criticism, media reporting. And I think we'll still come to the issue of the attorney, Malachi attorneys, and how they treated all this investigation, the issue of the YouTube, what led to that. So I think also to bring issues into perspective. So the investigating report, you say I must read it, or you?
No, I can do it. They said the investigation and report fell outside the jurisdiction of the public protector as it related to events dating back to 2009 and 10.
Yes.
No exceptional circumstances have been presented by the public protector justifying the investigation after an extraordinary lapse of time. Also, despite the fact that the previous incumbent had already in 2014 received a complaint about the alleged unlawful establishment of the unit, but elected not to investigate the complaint, the public protector nonetheless proceeded with the investigation. So the last part, I think, has been clarified, that this is just the 2014 thing was about HR, and in any event, the intelligence unit part was being investigated by the IGI. I think we've dealt with that. So I wanted us to deal with the first part, which is your bias based on the fact that you exceeded your jurisdiction. Well, I think that's what it says.
This is not correct, because in the report, when we were conducting the investigation, there were letters which were written by the attorney of Mr. Kodan, where he indicated that.
So people can lift up their.
Yes, closer to the mic.
Okay, it's not true. And the matter was brought to his attention during preliminary investigation. And the issue of special circumstances, which I propose we read what section 6 of section 9 says. Because special circumstances are determined by the public protector. It's at the discretion of the public protector. And if there's a complaint that this incident is still ongoing, people's lives are still under threat, or people are being monitored without their knowledge, without the approval by the judge. Chairperson, I also said I saw the video, which I was still trying to trace, which I didn't include here, but the issue was, if the unit is still, those cameras which were installed in 2014 or 2015, they were still there, they were still operational. And then the complainant even indicated that there is an incident where one of the acting director of public prosecutions, it was Dr. Ramayite. Yes, I think was saying the publication of what he did in the office in the media was as a result of what was captured by those cameras. So, and the indication that some information which was sent to me, which we will also have to show, because there were some emails which were shown here, blown out of proportion again, that I'm saying Mr. Godan is a threat to democracy, are things which were sent to my email, which I would copy from either Twitter or my private email, then send it to the investigators to take note of. So others were even saying so and so was killed at the driving to this particular place. So that's all the information which was coming forward. Now the question, as a responsible public protector and investigating going deeper into the credibility and the correctness of the information, and the fact that we cannot have a situation where, yes, it might happen to the DSO, it might happen to whoever, but is it fine that it should continue to happen where you are living your life? Information is being recorded and tracked on your life. You are not being investigated, because yes, they are within their right, if they are doing the issues of tax, to do that, but let them get the approval of the judge. ukuthi one day, if you would want to take them to task, they've got that approval and they must tell you what were they investigating about you. Not an issue where you are being investigated, you are being followed, you are being tapped and listened to. That's a violation of your constitutional right and your right to privacy, because now they will record whatever you are doing in your private space. Yes, possibly if people are doing anything in the office which is not right, but then at the end of the day, you are now faced with this information, you are being recorded or you are being kind of, because there were allegations that others are blackmailed. You know, because now they've recorded you, they have this information about you, Advocate Mpofu, and you were in this room and in the hotel and you were doing the following. Now, when you are supposed to do anything, they just say, we have that information, don't forget. So it was just making sure that this, if it's happening, hence my discretion was, let's look into this and let's reflect on the issue and let's stop it from happening. Let's make sure that people who should be doing that and using those intrusive equipments are SSA. But secondly, if it's SARS, let them also inform you, because you remember yesterday I read what the SARS Act, or even earlier this morning, what does it say about investigation? So you need to be told, you need to be given the outcome.
Okay, we'll take a 10 minutes tea
Thanks, Chair.
from that point. Can we
you.
pause for that?
Yes, Chair.
Thank you. And then we'll
Okay.
come back to the qualifications when we come back.
Yes.
Thank you.
Recording stopped.
Back to our last session of the day. Hope you enjoyed your tea. Advocate Mpofu, over to you on your qualifications or any finishings.
Yes. Thank you, Chair. Annette, if you just allow me, Chair, to go back to the issue that I was busy with, just one or two questions. PP, this section 6.9 point. I just want you to confirm that we will deal with it because it's a bit of a legal argument, really, about the interpretation of section 6.9. And it's the main issue being whether that is that 2-year period referred to in that section is meant to be a restriction to the public protector or not. Because some people read it as saying, once the complaint is 2 years old, then you are barred from getting into it. You read it, and I, for that matter, read it to say that even if a complaint is more than 2 years, you have a discretion as a public protector, depending on a whole lot of things, the importance of the issue, whether it's ongoing, as you said, and so on. So there's one can say the jury is still out on that, whether it's a permissive section or a restrictive one. But those are just the legal niceties. What I want you to confirm is the fact that that question of the interpretation of section 6.9, at least at the time of this report, when you were doing this report, had it been settled by the courts or even decided by the courts, let alone settled?
It was not. It was still the belief, or I also took it on the face of it. Hence, I said, Chairperson, if you read section 6, subsection 9, yes, you'll argue. It will be the legal argument, but I think if we can go there,
Yes.
for one to just read for the public and the committee members to also understand how it read.
Okay.
And if you apply the discretion, because it's very clear, well, when you argue, you will have to show them the provisions of the Public Service Commission Act. I think that's the one, if you can check it, if I'm not mistaken, where it's very restrictive. It says once that happens, you don't even entertain.
Okay, maybe the convenient place then, just because we've been dealing with the judgment. It's in the report, but it's also in the judgment. Okay, we can do it from the report. Look, let's see. Might be easier to do that.
The report, look at the beginning. Why we accepted this, because I think we were asked to indicate why we are investigating. And by then, page 9 was clarifying what are the special circumstances which one was considering.
Yes, okay, but yeah, the section is not reproduced there.
Yeah.
Okay, let's go to the judgment. Paragraph 20, Tsepo.
Okay. Paragraph 20.
Yes, 20. In any event, while she's putting it up, assuming whatever the interpretation of section 6.9 is, can it be applied if the transgression is ongoing? Or
Definitely.
should it be applied when something at least is still is ongoing as you do it? In other words, the 2 years, when does the 2 years is it supposed to run? Isn't it at the end of the occurrence?
Can you repeat yourself?
Can section 6.9 be used against the public protector when the transgression in question was ongoing when the investigation was conducted?
No.
All right.
Hence, I'm saying at the time I was reading section 6.9 as it's captured.
Yeah.
And maybe allow me to say, I would still want us to go to that page 10 of the report, because it will show you why we continue to investigate. Section 6.9 as well, Chairperson, is at the core of the ombudsman, of the public protector. You know, when I go there, actually, well, it's very close to my heart. And, you know, I'm so passionate about it in the sense that I don't want to say I'm emotional about it because I might end up being emotional. But the fact of the matter is you find Ukoko Dlamini, you find somebody who has been trying, knocking all the doors. And at the end of the day, they are failing, they are being failed by the system, by all the other offices. And at the end of the day, they then approach the public protector. When they come to the public protector, well, now as public protector, you don't use your discretion. You just tell the person, no, as a complainant, because apparently currently is what is happening. Tell us, why do you think there are special circumstances? Special circumstances must be determined by you as a public protector. It's in your soft skills, because you need to understand that this person is suffering. Hence, even in this case of the so-called this unit violating the laws, people's rights, and I've mentioned before, Uguti, if you are then recorded, your life is in danger. That was what I was told it's happening. Hence the investigation and go deeper into investigation. I think there were some comments, no, you can't say you are conducting preliminary investigation and you go ahead, you approach the implicated parties. Because if you listen to that recording as well, where we had a meeting with Mr. Kodan relating to the Pillay matter, which we're still going to deal with. But the attitude was, why do you investigate? It means even if any person from the street just approaches you, you will just investigate. That's part of investigation, because preliminary investigation is included in investigation. So this one, it also then allows you as a public protector to use your discretion, not to close your door. Where must this person go? Because they can't afford to litigate. They don't have the resources. Our services are free. So I think that discretion, it's just the issue which I said, it was giving this institution that human touch, that issue of saying, forget about the legalities, because unfortunately this organization has been turned into something like a court now. And at the end of the day, using your discretion was to say, but what are the circumstances surrounding this person? And we've mentioned what are the circumstances we will continue to investigate. So can I go ahead and read section 6.9?
Yes. It's on paragraph
So it says,
20.
yeah, for the members of the committee and the public, except where the public protector in special circumstances within his or her discretion. Discretion is something which is, you can't touch. It's a soft skill, for as far as I understood it. so permits a complaint or matter referred to the public protector shall not be entertained unless it is reported to the public protector within 2 years from the occurrence of the incident or matter concerned. So it gives me an opportunity to use my discretion and in special circumstances. So that's how I dealt with this matter. And that's why, Chairperson, I will ask that we go to also page 10 of the report, where during our investigation, we then also captured what those special circumstances are saying. And again, taking into consideration the fact that we were asked, what are those special circumstances? And the lesson was, okay, we'll have to find a way of indicating that these are the issues we'll look into when we are investigating. Because then again, we are this institution now which must make sure, irrespective of the fact that we need to protect, but on the other hand, we need to also be compliant.
Okay. Now, maybe let me ask it like this. Alluding to the question of what is known as throwing the baby with the bathwater. Let's assume for a minute that the establishment of the unit, which it is common cause would have happened even on these facts. Let's even peg it at the time of the memorandum of Mr. Manuel to 2007. So you can't debate that that's more than 2 years before this event. Yeah.
Correct.
Let's assume you could exclude that. Now, what about the other issues? If the recruitment issue, again, maybe let's even assume that that happened earlier. But if those people were still working there, if the equipment was still there, and if the activities of the unit rogue, for the purposes of this example, were continuing, then would it be fair to then exclude the whole report, or maybe rather exclude then the establishment issue if it's too old, but the operations issue, which is ongoing, could be inquired into? Isn't that a better way of dealing with this?
Yes, it's a better way, because actually that's firstly the main reason that we needed to investigate to check whether indeed the activities of that unit are still being carried out. And also if then there's this information that besides the fact that they've been established to deal with tax compliance, legislation, and conduct the investigations under the SARS Act. But now if there's evidence or information before you showing that they are not doing that within the laws and the operations are contrary to how they've been established, then those allegations should be followed up. Hence, I'm saying we ended up including what were the special circumstances, or develop kind of some pointers to guide the investigators to also know that if the matter is still ongoing, and whether the seriousness of the allegations, whether the outcome of the investigation into the complaint can rectify the systemic problems in state administration. And remember, if we have to deal with the root causes and also people who are recognizing this institution genuinely, they would then learn from what we investigated and implement. So that was part of the intention. Hence, I'm saying page 9 of the report captures those things.
Yes. Okay, can you go to paragraph 23 of the judgment? And because I want to go to the actual, the real punchline on this jurisdiction issue, which is not about these legal technicalities. Just paragraph 23 of the judgment. So this is, yes, I can do it now.
Yes, this is exactly what happened. Upon the failure to elicit a response from the public protector, Minister Godan, through his attorney, pursued the matter further and again requested the public protector to identify the special circumstances permitting her to investigate the complaints against Minister Godan. The public protector responded on 24 April 2019 by stating that she had been reliably informed that the surveillance equipment illegally acquired at astronomical costs is still being utilized to intercept communications between people by the unit, which was not completely disbanded. So this was a matter of special interest as public funds are still being used for illegal purposes. So this is the continuation, and indeed it's captured here.
Yes. And then 24.
It would appear from the above explanation that this was a reference to the complaint regarding the purchase of the equipment by SARS. This explanation, however, failed to explain the exercise of her discretion over the remaining issues raised in the complaints.
Yes. Now, and this is the point I was raising, whether even if some of the issues could be hit by 6.9, let's assume for the purposes of this that they are, would then the entire report, even the ongoing activities, have to be discarded? But maybe
it can't, because I think it went further where they also saw the other factors which we take into consideration as special circumstances. So it means to them that's not justifiable.
Yes. And then let's go to 34.
Of the judgment. In conclusion, the public protector's decision to conduct the investigation was unlawful because there were no special circumstances present. The review should succeed in its entirety on this ground alone. However, if we are wrong in this regard and the public protector had the necessary jurisdiction to investigate the complaints, we will nonetheless consider the review.
Right. Now, so that now what that means for the people who don't read judgments all the time is that the judges were therefore opening the door to say, well, it did not have jurisdiction, but maybe we're wrong about that. And therefore we'll go to the merits of the complaint. Now, under those circumstances, when they themselves leave the door open to maybe we are wrong on this, can you use that as the basis now later at 290? You now say you are biased because we have no jurisdiction. What happened to maybe we are wrong? And that's really, I think, the gist again for this commission, rather for this committee. The most important thing is not so much whether the thing was 2 years late or you got the law wrong or whatever. The question is whether that lack of jurisdiction can be a basis for your impeachment, can be a basis for saying, okay, it was 2 years, you still did it, and therefore what? Therefore you are not fit for your job. That's the connection. How can you understand if that connection is valid or not?
That doesn't make sense in the sense that paragraph 34 is saying this. They are also acknowledging, well, they are concluding that it was not unlawful, there were no special circumstances, having read the report and what we considered. But they are saying, should the review succeed in its entirety on the ground alone? However, if we are wrong, they are also acknowledging, and then go into paragraph 290, Chairperson, and then say I was biased or I was wrong. So that's why I'm saying for you as the committee, you shouldn't just take the judgment and just conclude like that, because they themselves were not sure.
And
from my side, I was dealing with this matter openly, honestly, and yeah.
No, thanks for that. Sorry to disturb your flow, but as long as you understand that that's not our duty to just follow the judgments. If it was our duty, we'd have long finished this work. From the panel, there would not have been such a long process. Section 194 charges us to investigate and apply our mind. So I don't want there be a perception that ours is to rely. The judges are important, but we're not a committee that rubber stamps. And you did indicate that we're not here to reinvestigate, to relitigate those judgments. So the balance of that understanding is very important.
Thank you, Chair. I think that's that's right. And unfortunately, our duty then is to, because if we don't do anything, then the judgment will stand. So I think that we're on the same page here. Thank you, Chair. And the point really is this, and which is what we will argue at the end. And but I just want your comment, PP. The judges say the judges may be getting the law wrong on this section 6.9. But the same judges in the same breath say, if you get the law wrong on section 6.9, that means you're biased. But if they get it wrong, they're just getting it wrong. Now,
biased.
yeah, so that's the thing. How does it work? And this relates to an issue that we will deal with in the morning about the relationship between protecting the independence of the public protector and the independence of the courts. It's a whole discussion, yeah. But what I'm asking you is, how do you feel by being judged by a different standard? When you get it wrong, it's impeachable, but when a judge gets it wrong, well, the appeal court might fix it, but they go back to work the following day.
Yes, I think hence it's well, on the face of it is very much unfair, because indeed we've shown here the judgments where it was shown by Judge Malanga, Chief Justice Mkhwebane, the issue of magnifying the mistakes of the public protector. I mean, you know, sitting here for the past 8-9 months, being vilified, being labeled this person, actually even before then, I don't know the law and all those. I mean, hence judges, they do falter. They have an opportunity for their judgments to be considered in at a higher court, the issue of error of law on appeal. And when they have lost those cases, no one will come and hold this particular process. So with me, now they're holding this particular process. And unfortunately, Chairperson, because most of the way the Mazone motion was crafted and those charges, it relates a lot to the judgments and the language they've used there against me. So I'm just saying, and this point is very critical because it shows with them as well that They might have made a mistake, they were wrong, but they go and find against me that I was biased. So with this process, we're trying to show you that, I mean, when you consider these judgments as well, I'm glad that you are saying, no, they will be there, but then we are dealing with now the facts. And as well, I said to South Africans, hear me out. I was doing this work. This is what I was doing. But again, I'm also not perfect.
Yes.
Do I
Yeah.
have to receive
Sorry.
such harsh treatment, such humiliation? I don't know.
No, the little point I wanted to make before you proceed with Mpofu, taking from what the PP has just said, was I would encourage you to invest and spend more of your time in explaining yourselves here to the committee, other than a lot of time invested in those judgments, because it's us who must be persuaded.
Yes.
as the committee, but it's in the nature of the motion
Yes.
that you have those judgments. So there's no way out of it.
Yes.
So that is well understood. But also there's only one body that has to check the fitness to hold office of the public protector or any of those holders, is the National Assembly.
Yes.
None of the courts, in whatever judgment, they would never come close
Hmm.
to dealing with the fitness to hold office.
Absolutely.
That's our role. So I think if we understand that lay of the land, it's going to help, so that this is part of a jurisprudence development on
Yes.
its own.
Yeah.
Thank you.
Thank you, Chair. No, I couldn't agree more, Chair. And when we do the oral argument, I can assure you we'll spend the first hour or two just dealing with that issue, because it's key to this. As you say, it's inevitable. Unfortunately, the motion is not based on the PP went to work and stabbed all the workers there, and so on. It's based on the judgments, and therefore we have to navigate that. In fact, according to the independent panel, they say that all the charges, except for the charge of Mr. Samuel's affidavit of February 2020, are based on judgments. And that's the quagmire that we find ourselves in. So, and that's why, Chair, when I was doing the landscaping, I made that point clear, because I didn't want to ever to be understood to be addressing the judgments per se. We only address the judgments insofar as we want to address you. When I say you, I mean the committee. Yeah. Thank you. No, I think that clarity is important, and we will deal with it in legal argument. But maybe the most graphic way of illustrating this point, in the way of a question to you, Public Protector, is for us to understand that and in fact now it's even more relevant because it's time to appoint a new Public Protector. It is that one of the qualifications for being a Public Protector, apart from being admitted as an advocate or practicing as an advocate and all the others, actually I think the first one is you qualify if you are a High Court judge.
Correct.
And indeed, even when you applied, there were judges that had applied. I think one of the judges that was shortlisted was Judge Desai, and I think he withdrew because of that. So now, what this means then, the situation we're in, is that Judge Desai, protected by Section 165, let's assume it was he, not you, who was appointed. Protected by 165 of the Constitution, the independence, which means that if he gets the law wrong, he gets the law wrong. Judges get the law wrong every day. But suddenly, if he had become the Public Protector, the situation changes. If he gets the law wrong, then it's an inference of bias and it's a ground for removal. Now,
Yes.
as a country, this is something we have to grapple with. It's not as easy as I'm simplifying it now. Okay. So I'm saying that what as you are on the wrong side of that example, what should we do about ensuring that whatever the intention of the constitutional founders, mothers and fathers was in in fashioning the protections for both of these institutions, that balance should be kept to ensure the integrity, the dignity, the independence, the effectiveness of the public protector.
Mhm. They should be, because remember, the public protector is a constitutional institution, not only the public protector. I think what needs to be learned from this process is that the rules and these proceedings, the section 194 of the Constitution, as well as comparing section 181 of the Constitution and 165 of the Constitution, the independence of these institutions, they do the performance of their duties without fear or favor, and they are doing their work, and they should be supported by any other organ of state. And it's very clear that no person must interfere with the operations of the Chapter 9 institution, and similar issues applicable to the judges.
Yeah.
So I think here, I've mentioned yesterday or last week where I said, I think even yesterday, I said there are a number of judgments which have been set aside by the higher courts of those judges. I'm still repeating, you can go and check how many judgments possibly in this matter we are busy with, where the judges have found against me, and now the judges are acknowledging and saying, suppose we are wrong. And you'll check and ask yourself, they managed to do this. Now their judgments are set aside, some of them at the Supreme Court of Appeal or even Constitutional Court. And they are also damning comments from their colleagues. But are they subjected to what is ongoing? Because I think as a country, we should play the ball and not the men. I normally say that.
Yeah.
Whatever we are doing, we are setting a precedent, and which is very bad, because now if we do this against this public protector, what about the other public protector? What about the Auditor General? What about in future, then there will be an administration which will say, judges, Shonan Kon, you are also now, we have this impeachment proceedings for you. You found the following people guilty. Somebody has been in jail for 20 years for something which they've never did, just because of the mistake and the error of application of a law by that particular judge. So can you imagine how gross is that compared to what I'm accused of?
Yeah. Okay. And maybe, Chair, again, I'm mindful that we're not yet at the stage of the legal argument, but I'd like to, like yesterday I said, there's homework. This is the other homework, and this homework means it's not for tomorrow, it's for when we argue. And the one is this, and really, this is not a simple issue. If you go to section 165(4) of the Constitution, Chairperson, you'll find that it says the following.
What section?
165, volume 4, 165, subsection 4. It's actually uncanny. If I had a way, I would put them, both of them there together. But you'll see the point I wish to make, Chair, which I'll develop when we argue. It says
You-
organs of
you have, you can repeat this, you have taken us through this because there's a link between this and 181.
absolutely.
So
Yeah.
you have
Yes.
travel, but
Yes,
Please
no,
go
but let me
ahead.
make it now in this context. Yes, it's not just a link; they are identical. Yeah, that's the point really I want to make. So 165.4 says organs of state through legislative and other measures must assist and protect the courts to ensure the independence, impartiality, dignity, accessibility, and effectiveness of the courts.
Mhm.
Then go to 181.4. They are like identical twins. 181.3, sorry. Other organs of state, through legislative and other measures, must assist and protect the institutions to ensure the independence, impartiality, dignity, and effectiveness of these institutions. That would be the public protector. In other words, the constitutional mothers and fathers saw it enough to give the exact same protection, literally word for word, for the judiciary and for the institute, not just the public protector, the institutions protecting democracy. And it's always difficult to make this point because the cynics then say, oh, the public protector thinks she's a judge, you know. But that's not the point that is being made. The point is that the constitutional protection is the same. So, and then I think that takes us then, Chair, to this question of why is then the mistake of one impeachable but the mistake of the other not, but we'll develop that point further. Chair, can I therefore, I'll start with the qualifications issue, which is not long. When we resume, I think this we could break at this point. Thank you.
no problem. I think it's now 1700 hours. This is our closing time. So you are correct there. We'll pause there and then.
Yes, Chair. I'll give. In fact, I wanted to give you the 3 topics that I will deal with so that people can prepare properly.
So there are 2. They can be 3 now. So it's qualifications and those general. Which
yes, no, on the report.
So that's the second.
On the report.
So what is the third one now?
No, that's just on the report, Chair. Then we have the remember, we still owe you maybe 3 or 4 of those from those 9 points of the charges. I think we've tackled about 4 or 5 of them. And as I say, I'm trying to deal with both. So because if you do them sequentially, it will be many issues. But now we've already killed some of the others.
All right.
But I'll do a quick roadmap tomorrow morning.
That's fine. Then let me just therefore before we close, go back to my promise to assist Advocate Mpofu and your team on the issue that you wanted to off-ramp about. So, you know, when there's a bus and somebody wants to go to Kama station when we've just started. So I refused that off-ramp. And you wanted that off-ramp on the basis of your doubt about the status of the meeting.
Yes.
And I promise that I will clarify the matter because I immediately connected with what your concern was. And I don't blame you. I want to start up so that you maybe in future will be in one, because you are concerned about, which is my concern too, and should be everybody's concern about the meeting, about what I think you thought you saw as a shrinking meeting. Firstly, let me explain that, and this is something you notice every day we start. Our quorum arrangements in the National Assembly, we have made them to be kind of, call it a hybrid or 2-way. So we have a number that we use to start the meeting. We also have got a second number for decision making in a meeting. And so in a committee of 36, if we are to get into making decisions, minimum we need 19 and above. But to start a meeting, as I always do every morning, I never start a meeting when we are less than 12 or 13 members. So firstly, I want to share those two. It's done not only in this committee, it's done across in various other committees. You might not know that. Hence, I wouldn't want to blame you for wanting to raise the issue. So, and I would have indicated to you, and you also gave me the number later on, that at the time when we came back, 1401, we certainly did not have 19 members present in the meeting. You gave the number,
Yes.
but there would have been, even before you raised that, I would have known how many members. It was even less than 14. Because you giving us even 2 more. So there were about 12 members at the time just before you raised that.
Okay.
12, including myself, who would have been present in the meeting. And therefore that plays into the space of starting a meeting and continue with the meeting. And then, because your concern was, okay, yeah, that's a second one which I must address about, because in a letter to you, we requested that the public protector would prefer that she be present here physically. So in your own way, you have kind of thrown that thing.
Yes.
In the process. Just to explain that this week has been a very difficult week, because this is the last week of the National Assembly before it starts what we call recess, constituency week. So from next week, we are on constituency week. In the same way, we're in constituency week when we started the inquiry on the 11th of July. All other committees were called and they were on holiday. We don't have that. We're not going to have that as this committee. So many committees are on what we call oversight, either in different provinces. So members are looking from the spaces where they are. That's one of the reasons why you don't see many of them physically here, especially this week. Certainly the situation is going to change from next week in that regard. So because they are dealing also with other issues of national importance. But the last meeting of our committee, I would have raised a number of risks that we're facing in this process, including that risk that you would have come to you in writing, but I'm not there on that one. We can speak about that either tomorrow or any other time.
There's only tomorrow.
No, I don't know about that. We have a scheduled program, but that program depends on some of those risks mitigated. So your point there is taken. So I would have raised with the members that one of the risks is them forfeiting, for example, even their constituency period, on the basis that there's work that needs to happen. But members of the public, yourself, must be assured that numbers are continuously monitored, so that we never get into a space where we're compromised in that regard. At least in that way, you will be the first to say that that chairperson never starts a meeting if it is less than, because we've done that live, even if it helped others who would much walk in late, and I won't mention names. But monitoring those numbers, also the important thing is that everything else that we do that is happening, all members would have an access to. So for example, you would have a situation where I am aware that there would be either members not being able to consistently attend this meeting. I mean, I was making a light joke this morning with General Olomisa before the start of the meeting. And I was saying to him in Xhosa, you are in and out in this meeting. His argument was he's dealing with national issues of national importance. And so, but it would have been in the morning, and then, so you can imagine if you have members of the ATM not here, members of the EFF not here, members of AIC not here, and some others come in, or even if all of them are here and at the time when you come back, they are outside, how a meeting could be disrupted, the proceedings, if you were to follow physically where they are sitting and so on. But I don't want to elaborate. I hope the clarity I'm giving would help the issue that you are raising. And as I said, I'm not blaming you, but I thought I did not want to give that explanation at that point.
Okay.
As I always do, I never want to disrupt the flow.
Yeah.
But the flow was being disrupted by the initiator. So I had to protect yourself against you in that regard. So I thought I must just make that explanation on record in relation to that. Thank you very much.
Yeah, no, thank you.
Members, and thank you. Not forgetting both.
No, thank you, Chair. I was also trying to protect you against yourself.
I can
in
understand
running a meeting that is not correct. But, yeah.
Thank you.
Thank you, Chair, for that explanation. Okay. We'll have to look into it. And the other issue, Chair, I don't have time now. Maybe we'll address it tomorrow. But as we know, there is that other serious issue. But a
little space tomorrow to attend to some of those issues.
Okay. Thank you.
Thank you.
Sure.
Thank you, colleagues. Everybody else, the meeting is adjourned. We start tomorrow at 10. Thank you.